Actually, story, my lord. The ingredients of section 7 and section 12 is not made out, my lord. My lord, may I kindly see page number 16.
16, huh?
My lord.
Okay, FIR.
My lord.
Okay.
The story is that, my lord, one
Charge sheet is filed?
My lord, charge sheet has been filed.
Okay, cognizance.
Cognizance has been taken.
Okay, where is the charge sheet? Let us read the charge sheet first.
My lord.
Forget about the.
The charge
Yes, 67.
is
This is the big list. What is the allegation?
my lord, the story is that, my lord, one complainant had lodged an FIR saying that this present petitioner, who is a ex-inspector of vigilance, my lord, she had told that one Mukesh Shahu is there who can help you in solving a case regarding a pending departmental case regarding the complainant.
7 is made out.
My lord, he has said that that is the allegation, my lord. No
allegation will be tested in the trial.
My lord, the only point is that the bare perusal of this charge sheet event, there is no actual demand and there is no actual.
That is, see, it's not necessary. 7, if you have put someone in between and try to influence, then 7 comes, 7 and 9.
My lord, here there is some lapses, my lord, on the part of the authorities. What they have done is, my lord,
all lapses, all these things is on trial.
My lord, the lapses is on trial, but the actual reading, my lord, may kindly see the FIR.
No, you come to 67.
My lord.
Page 67.
My lord. My lord, here, my lord, may kindly say, I'll not take more time.
What is the name of the accused?
Manasi Jena.
Manasi Jena. Come on, 67, read it.
My lord, the brief history of the case is that on 17/3/2022, Srimati Manasi Jena, Inspector of Police Vigilance, Sambalpur Division, contact complainant Sri Lakshmikanta Padhi over his cell phone number so-and-so from her mobile number and asked him to attend Sambalpur Vigilance Division office for some inquiry. As he was busy in some official work, he could not visit on the said date. Srimati Jena repeatedly called him over to attend her office. On dated 24/8/2022, after talking with her, Sri Padhi went to Sambalpur Vigilance Division office and Inspector Manasi Jena in her office chamber about 8:45 p.m. The Inspector Manasi Jena informed him that the allegation has been lodged against him and his house was going to be searched in the month of April. She further told him that as he is a class 1 officer, his case could only be closed by government and for that one Sahu Babu, an OS officer, would help him. She talked with Sahu Babu over mobile phone in his presence and gave his mobile number so-and-so to Sri Padhi and directed him to contact that man. Accordingly, on 25/3/2022 morning, complainant contacted Sahu Babu over his mobile telephone number. As per direction of Sahu Babu, he met him inside the CRPF campus situated just before the town on Bolangir Bypass Road. Therefore, Sri Sahu discussed with him about the case and informed that he has good rapport in the government and he has to pay a good amount for closure of his case. On that day, after returning from Bolang, complainant Sri Padhi informed Inspector Manasi about his meeting with Sahu Babu. Inspector Manasi Jena gave him impression that Sahu Babu is the only person who can help him.
Enough.
My lord, only he can help him. My lord, this is the allegation, the mere allegation. No.
I understand.
My lord,
by the time he read, I read the full.
My lord, here the main thing is that my humble submission.
I can only tell that it's a good try.
My lord, just for a moment, if my lord,
yes,
my lord, here, the actual money which was demanded, it was by the President Sahu Babu. The so-called Sahu Babu has demanded that money. And the raid, when the trap was there, the tainted money was recovered from him. There was no, in the FIR story, it's something different. It is contradicting. The charge sheet story and the FIR story is contradicting to each other.
No, after investigation, we can't test the charge sheet on the basis of the FIR. FIR is only the information. Mansi is the main accused.
My lord,
Mansi is the main accused.
My lord,
basically he put that Sahu Babu in between. And the Sahu Babu started demanding and then everything. What is this?
My lord, but the My lord, I may place section 7 of the PC Act.
I know by what.
My lord.
Read it for your service.
My lord, I will just place that. My lord, here the allegation is something different. The charge sheet story is something different. So, my lord, here the prima facie
It is
case
at a cognizant stage.
my lord, sir.
If 7 is not made out, 9 is not made out, if on the basis of this, is it the stage to look into it?
My lord, here
You are virtually asking me to discharge him from 7
no, my lord,
or 9. Is it the stage? You tell me.
my lord, I go down to that, my
And
lord.
then
My lord, just a prayer. If my lord may permit,
will you withdraw to raise this before the trial court at appropriate
my
stage?
lord, I filed an I actually the present petitioner's husband is suffering from.
I understand it. That is the reason 482.
That's the reason, my lord. If my lord may permit me, if that the time petitions, if for a just some months, my lord,
I'm intending to dismiss it, and while dismissing, I give relief also. Huh?
my lord, just
I'm intending to dismiss it. What do you say? Whether you will withdraw it to reserving your right to raise all these points at the appropriate stage?
my lord, as my lord,
Simply withdraw. That's the better idea.
my lord, with the
In any case, liberty you have.
my
In
lord,
any case, you have liberty.
my lord may mention that if I was just for sympathetic ground, my lord, I am praying that for some period of time it may be stalled because my lord, the present petition is suffering for.
Does sympathy recognize in law?
No, my lord, that doesn't. But my lord, that's I had filed for on a medical ground, my lord, I had filed.
You have done very well, but I can't help you. Right now, then counsel for the petitioner intend to withdraw this petition to raise all his contentions before the trial court at April 15th, and seeks liberty accordingly. The petition is dismissed as withdrawn, liberty granted as read.
Much obliged.
Grateful, man.
Yes.
I told to
Dispose of. Yes.
Maybe errors.
Yes.
Maybe.
Yes.
Last occasion, Lord was pleased to direct my Lord and friend Miller to call for the status report of the case. Here, Miller, the prayer is to Miller, the impugned order is annexed 4, my Lord.
From losing it in the coal mine and even not been paid.
Prayer to
And is that the non-payment of bank account grading number shown so I increase therefore not yes.
My lord, the investigation going progress, my lord, going on.
No, that's right. But how can you freeze the account?
My lord, for the purpose of investigation, my lord, that is required, my lord.
First of all, this is basically a recovery proceeding.
My lord.
And he says
My
that
lord,
he has already paid. What? Huh?
That is the observation of this honorable court, Miller, while granting me anticipatory bail also. It has been reflected in the order, madam. That is why, Miller, on the last occasion I pointed out, Miller. Lord, we kindly see fast, Miller. I want to, Lord, Miller, draw your Lordship's attention, Miller. The APR, Miller, is at page 12. Miller, here, Miller,
Not
here
required.
said that it is
Not required. We have taken instruction from the investigating officer that account which has been freezed, that is not no more required for investigation. You have received the
So
instruction.
then we
Yes,
can
yes.
defreeze it.
Your lordship.
Defreeze.
Yes.
The present matter was taken up by this court on 9/1/2024, and following order was passed. Order reproduced for the para 2. Para 2 से देखिए. Mr. Ragada appears for the state and on instruction submits that the investigating agency has informed him that the freezing account number so and so of the petitioner is no more required for the purpose of furthering furthering the investigation. Therefore, he says that there is no impediment if the account is defreezed. Next follow. Accordingly, this petition is allowed. The account number so and so. What is your prayer in the application? Where is that application? Defreezing wala application?
But that application I have not annexed, but the order I have annexed. Here
Where
the
is-
prayer is not.
Where is that order?
Order is not annexed. The initial order is not passed by the learned trial court is annexed 3, my lord.
Why, by which your application of, is rejected?
Annexure 3, my lord. At page
Why-
18.
I am surprised. Why are you not, you are such a seasoned lawyer, such a senior lawyer.
My lord,
Why are you so reluctant to file document? A order is passed by the trial court on the basis of some application.
yes, my lord, sir.
Will you not file that application?
I am extremely
I
sorry.
have to see that prayer, what
Yes,
may
my lord,
the
but
prayer was made.
457 application, my lord,
These are minimum, very, very
Yes.
minimum.
that is not available with me, my lord, while I was drafting the case, my lord. That is why, my lord, I have not annexed.
Then you should not have filed the petition 482. You should have asked your client to give all the documents.
I am extremely sorry.
Very, I have no clue what was the prayer.
Prayer is, my lord, to defreeze,
Huh?
debit defreeze of the account.
Direction to be who? Direction to the IO.
Yes, my lord. To the bank, my lord, is also, my lord.
Bank is not a party. How can you give it
No,
direction?
the
to
bank is
482?
not a party,
Huh?
but
That is why I wanted to see the prayer of the
Yes.
application. You have the application.
Lord, that application is not.
You might have prayed something
Yes, no, no, Lord, that
Order is
application
something
not
else.
with me, Lord. Otherwise, Lord, I
and
could-
you are asking something else here.
no, Lord, that application is not with me. Lord.
On this ground alone, I should dismiss this petition.
Lord, see, kindly see, Lord, in annexure 3, in para 1, Lord, my prayer has been written by the learned.
Annexure
Lord, see, kindly come to page 18, my lord.
18. Okay.
Yes, ma'am.
Hmm.
Here, my lord, in the first para, my lord, prayer, my lord, for unfreezing of the current account number so and so, my lord, which was freezed by the IO in connection with GR case number so and so, corresponding to Collier number so and so.
Allowed, and the IO of the case is directed to take appropriate steps to defreeze the current account of the petitioner bearing number, if bearing number, you take it from this page 18. First column.
The order of the both the court is set aside.
Hmm?
Order of the land court bill
Obviously,
and
that goes
Matter.
without,
it is set aside then only.
huh? That goes without saying.
Setting aside, while setting aside the order of
The
both the court,
instruct-
say lots of director IO to
This instruction, your lordship may kindly take it up on note.
will give the matter.
Note I have recorded
Yes, yes.
here.
We have giving a copy of the.
Yes, one copy maybe.
And उसमें देखो mention रगड़ा जो instruction ऊपर लिखे हैं ना क्या लिखा है उसमें रगड़ा the written instruction is placed on record.
But
Please on.
Yes.
Allowed the order the impugn order dated so and so impugn order dated
both the courts.
impugn order dated 22/10/2022 passed by the ASJ Talcher and 29/8/2022 passed by SDJM Talcher is set aside and the IO is directed to take a henceforth, I am thinking that if incomplete documents and all are filed, 482 petition will be dismissed on that ground.
My lord, I'm extremely sorry, my lord.
Then what will happen is the message will go to the younger generation of lawyer that so casually you can't approach the High Court at least. See, that is why the younger lawyers are learning from you. If the senior counsels are doing like this, the younger will learn the same thing. Passing up the entire criminal prosecution, what is the annexure? Only FIR. 3-page petition without any averment, and annexure is one FIR. and you file in the High Court, exercise, ask the High Court to exercise 482. How can it be possible? Just
Henceforth, we will take care of the things.
so therefore, the younger generation at least they should learn to prepare an exhaustive petition with all available, necessary document at least. This younger generation has to learn. Yes.
Item C.
Thank you. Yes. 3, na? Yes. Pass over.
Item 4.
See this petition, cognizance order is challenged. Huh? Only the order is filed. Nothing. Yes. 4.
Item 4.
Challenging the order dated 1/2020.
Yes.
By the order by CJM, rejected the discharge petition, and thereafter the additional discharge that has been confirmed the order of the CJM.
What was the order?
However, I have filed the petition for discharging petition because you are the peon in the society, and absolutely there was no allegation against the present petitioner with regard to misappropriation or the any misutilization of the funds, because it's a peon to that extent. 41, section 41 of the Orissa Property Act provides, my lord, only officer will deal with the official records and the transaction made in there. So here is the present petition is a peon, and intentionally he has been implicated in this case, and 406 and 409.
What is the allegation in charge sheet?
Charge sheet, your lords.
Where is that charge sheet?
That's not given. Okay, that's the end.
Charge sheet,
That's not filed.
and I have not filed, my lord. Although it is with me, I have not filed. I am filing the sorry, my lord, because it was less. I have got it.
Investigation is complete. Charge sheet is filed.
Right.
Cognizance is taken.
Later on, I have
You have challenged, and the main document is charge sheet. That is not.
Later on, I have this. So I will filing my lord to let it go.
Adjourn it
Yes.
to the appropriate date for
Next week.
facilitating.
Today I will
Next week may not be possible, sir. Just see lot of matters. And see, I'm trying to follow a system.
System.
That system is derailed. That's the whole difficulty. If the matters are listed, if you argue, then the system goes on.
Yes.
Otherwise, see, sometime what happens, I'm free by 3
Okay.
o'clock. All matters are adjourned. 1 hour judicial hour is wasted. So that is the whole difficulty.
Problem.
He will adjust it and give it. But meanwhile, you please file it.
Mine.
Okay.
Item 5.
Yes. Pass over.
Item 6.
Pass over. 6, you are there? Okay. Come on.
May I please, Your Lordship?
Yes.
Petitioner in this case is challenging the order dated 8/8/2023 passed by the learned additional district and session judge, First Track Court, Pyongyang. The petition under section 311 was filed for recall of witnesses, my lord.
311.
My lord,
PW 1, 2, and 3.
my lord.
Yes.
That was rejected.
Show me the order. 88. That is annexure 4. What
Right.
was the reasoning?
Page number 22, operating parties there, my lord.
You are the accused, huh?
I am the accused.
One of the accused.
One of the accused,
Mohan,
but principal accused, my lord.
principal accused. So, what was the reasoning of the
My lord.
trial court?
Having heard the learned counsel for the parties on perusal of the case.
Where are you reading?
Page number 22, my lord.
22.
2.
Okay. Hmm.
It is found that victim as PW1 was examined on 23/10/2017. Her father PW2 on 5/5/2018. And her mother PW3, who is the informant of this case, was examined on the same day. If defense felt that this should be further examined on recall, a petition should have been filed to that effect immediately after the discharge and not waiting for such a long period. In the meantime,
When have
14
you filed the application?
application was filed on 28/3/2023.
Annexure 2.
My lord. Lord, here there is a development in this case. If your lordship will come to
Now, what is the explanation you have?
my lord, the
18 they were examined,
my lord,
17 and 18.
Right.
And 23 you are moving application.
this is a different case, my lord. the victim in this case, he has got married to the petitioner in the meantime, and they have got a child.
Settled the dispute.
Well, they, for that reason, they need to re-examine the.
You have settled the dispute. Why are you subjecting the mother-in-law, father-in-law, everybody to?
No, but the PW1 is the.
Prior to
victim.
that, they have been examined, my lord, in
They have
17.
been examined
They have
prior
been, my
to
lord,
settlement.
when they came to know conditions,
By
they
that time, they have.
must be there. For that reason, they have settled the
Because
dispute.
376 and all.
My lord.
You will examine them, get them
I could get
hostile and get an acquittal.
Well, he was released on such a condition that he will marry the petitioner, marry the victim during his release period. Conditional bail was granted. He married.
When the marriage?
The marriage certificate is page number 18, my lord. 10/3/2023. Recently. 10/3/2023.
Can I record all these things?
Yes, my lord.
No. How
No,
can I
that-
record for
that
311?
The marriage part, my lord, that can be recorded.
Why have you not filed quashing?
here. I meant to
Instead of indirect way of
Eight
appealing,
quashing file
you should have filed quashing
would
in
look at that.
ground of settlement.
Would
Both
look
of them are major.
My lord.
POXO is there.
No, Boxo is there, but now they both of them are major.
Oh, now when the offense has taken place,
Offense,
POXO
then
was.
Boxo was there.
Female child also born.
Look,
The
the
birth certificate.
petitioner has filed assailing the order dated 8/8/2023. 8/8/2023 passed by learned AD Additional District and Sessions Judge FTSC fast track Kyonjar in special case number 283/118 of 2016. Whereby his application under section 311 CRPC for re-examining PW 1, 2, and 3. Who is one?
One is the victim. my lord.
Victim person.
Victim, you can't call victim.
Also is there.
Who is the informant?
Informed is the father.
164 is recorded.
That should be recorded.
She has said that
My lord. But I would have come for a quashing, but the learned court below is pressing for disposal of the matter. More 7 witnesses were there for examination, but the learned court below had posted the matter for accused without examining those witnesses.
only 4 क्या करेंगे? 1, 2, and 3. 1, 2, and 3. The learned trial court by the impugn order has rejected the prayer of the petitioner only on the ground that the witnesses were examined in the year 2018 and the application for recall of the witnesses was moved on 28/3/2023 on the ground of delayed application. The delayed application, the prayer has been turned down. Therefore, the petitioner seeks interference of this court. The counsel for the petitioner also submits that in the meantime, the petitioner, being the accused, has married the PW1 on 10/3/2023. From the wedlock, there is a
Child of 7-year-old.
7 year.
7-year-old.
7 year marriage is on 23. She was
Pregnant by the time.
By that.
all complicated. What do you say? Make 7 years. There is a child. There is a child. Full stop. Although the factum of the marriage is not relevant for the purpose of the present petition. But the reasoning of the trial court that the application was moved in a belated stage may not sustain the scrutiny of law. Therefore, I am of the view that I am of the view that the impugn order is liable to be set aside. A single opportunity shall be afforded to the petitioner to examine all the three witnesses.
On the questionnaire filed before the trial court.
all
Specific
the
questionnaire they have filed
witnesses
already filed.
prior to recalling these witnesses, the petitioner should furnish the questionnaires.
Already
proposed
furnished there.
questionnaires to be put to the witnesses. The relevancy of the same shall be examined by the learned trial court and afford a single opportunity to examine these witnesses. The petition is accordingly, the impugn order is accordingly set aside, and the petition is allowed.
Obligation.
Item 7.
May I please? Well, here the petitioner seeks a direction from the Honorable Court for the early disposal of the trial pending in the court below.
FIR,
FIR filed answer 1 million.
what was the date of FIR?
Answer 1 page 12.
16. Charge sheet.
That sheet has been filed and now most of the witness has been examined. I also be examined.
So I examined the prosecution witness is over. Now it's you in your ball is in your court. Accused statement will be recorded.
No.
It will be recorded only accused statement and defense evidence. I don't know how much time. You can't blame the prosecution. Prosecution has done his job. IO is the last witness generally.
Only another IO is there. Rest of the witnesses are examined. Only one rest.
So then it is virtually fake end up. Learned counsel for the petitioner has moved this application seeking a direction from this court for expeditious disposal of the trial in ST case number 119 of 2017 along with ST case number 41 of 2017 and ST case number 108 of 2017. How many cases? 3 cases.
My lord, only one case. This is a case of double murder. This is a case of kidnapping and murder.
How 3 ST case, 3 ST case?
My lord, one incident, one is two FIR has been lodged.
I am asking something else. If there are 3 ST cases in one petition, how can you ask?
Absconded, the accused persons absconded. Subsequently, they have been committed.
Whatever, there are separate trial.
No, only one trial.
One trial.
One trial.
Accused person surrender defense time. From that is my lord saying.
Sir. Okay. But these trials are going analogously. Yeah?
Analogously, madam.
There are 3 other accused persons were apprehended subsequently. So 3 numbers are given, but one trial.
One trial.
Then counsel for the petitioner submits that all the prosecution witnesses has already been examined by the prosecution. The last witness examined was the IO of the case, whereas the other IO has not yet been examined.
Continuing. That I have to continue now. Last IO is continuing.
Last witness.
The last witness examined was the IO of the case. And the other IO was
the recording of the evidence of the other IO is in progress. Therefore, the trial is virtually in a concluding stage. In full service. In that view of the matter, no interference of this court is required at this stage. However, it is expected that the trial court will take appropriate measures And the trial court will do good to see that the trial is concluded expeditiously. Discuss. Next.
Item 8.
Let's turn to page 62.
63.
62.
Yes.
This is
Yes, sir.
dated 13/1/2023. A complaint was made.
1 minute.
It's a vigilance case, I am supposed to mail copy to be served to Vigilance Council.
I think that will be good. Then, sir. State is also part. Page 62.
Yes.
The one complaint was made against the petitioner and some other officer. The complaint has alleged that a huge amount of rupees 2 crore 21 lakhs or more was spent during the year 2015-16 for gap of so and so. This was made before the locate. Locate also see that it was made. The complaint was made before the locate, and the locate order is at operative portion at page 64. Page 64.
Yes.
We have carefully perused the investigation report. It clearly revealed that so and so, myself is there. Sushant Kumar Samantrai, who was the Deputy Conservator of Forest, have misappropriated government fund amounting so and so by preparing a fake voucher and muster roll. The finding of misappropriation against these officials are well reasoned. Next slide. We therefore accept the investigation report in totality, accord permission and direct the Director of Vigilance to file the charge sheet against them for offence on section 13. To read with the 13(1)(c) of the Prevention of Corruption Act, read with so and so of the Indian Penal Code. Then also kindly come to page 134. 134.
134.
Yes. I challenge that. The petitioner challenged that before this honorable court, the locate order.
Okay, 134.
The
yes.
order of this honorable court is page 134.
Yes.
Para 3. Matter is entertained only on the premises of alleged violation of the provision under section 23 of the Locate Act. Sorry.
Which mandate?
Which mandates a supply of copy of the report and providing an opportunity of hearing on the allegation involved herein that even though an inquiry was conducted by the Director of Vigilance, there has been no service of copy of the same and there has been already direction of charge sheeting the person concerned therein on the basis of such report. Issue notice. Let's come to the next page, page 135. So for the interim order is concerned, as an interim measure, it is directed that there shall be no effect to the order dated 13/1/2023. We just now placed people ourselves. Involved herein under Annex 4 without leave of this court till next listing. Then kindly come to page 136.
Yes.
I filed an application. So that is the next page you also can see. I think that I filed an application before the charge sheet is submitted. That is before the additional district and session judge, enclosing the copy of the order before the additional session judge. At page 151 also is to stay the proceeding in the above case, awaiting further order of the Honorable High Court of Orissa in WPC number so and so, and for these accused persons as due course and ever present. Now the order, impugned order, also kindly come to page 155. Impugned order.
What happened to this pending?
Pending, it is still pending.
Still pending.
No counter has been filed, nothing, but that pending still.
It will not be acted upon, it is still
That's
operating.
right, that's right. Interim order is operating. Interim order.
What happened now?
No,
Why have you moved the application then?
I
There
moved
was no
because it proceeded. Also look to page 155. 155.
55.
Yes.
155. This impugned order, huh?
Yes. 12/6/2023.
155.
Okay.
Yes.
The Vigilance Council will be present below.
Just. The
And
case,
just I'll see.
Yes.
Let us see.
the case record is put up today for hearing on the point of charge. The accused persons are absent and their advocates have filed petition for adjournment as well as petition for representation.
He was proceeding to frame charge.
Yes. Proceeding, also, just a minute.
Huh.
The learned advocate for the accused person submitted that since a writ petition hearing number so and so is pending in the Honorable High Court challenging the initiation of the proceeding, it would not be proper to frame charges against the accused person. Whereas the record does not reveal that any order passed by this court in this case has been challenged before the Honorable High Court. In the aforesaid writ petition, no order has been passed staying the proceeding in this case. Hence, there is no impediment in proceeding with the case. It reveals from the record that charge sheet has been received since 14/2/2023. Order was passed by this Honorable Court on 9/2/2023 at page 134. Charge sheet was received on 14/2/2023 and cognizance for the offence was taken on the same date. But as the accused persons are not appearing in court in person, there has been a delay in pending charge. In the other, all the accused persons directly.
Why the High Court proceeding is prolonging?
in fact, I have the memo has been filed, but has not been listed. They have not filed counter till date. State has to file the counter. And as you also know that provision as provided on section 309 of the CRPC, that 3092 also look to that provision.
CRPC 30.
Yes, sir.
Yes.
309, power to postpone or adjourn proceeding. Every inquiry or trial, the proceedings shall be continued from day to day until all the witness and attendants have been examined. Then to kindly come to 2. If the court after
1 minute, sir. 1 minute.
Sorry.
Yes.
309(2). If the court, after taking cognizance of an offence or commencement of the trial, finds it necessary or advisable to postpone the commencement of or adjourn an inquiry or trial, it may from time to time, for reasons to be recorded, postpone or adjourn the same and such term as
It is regarding adjournment of a trial.
Right.
After framing of
So,
charge.
postpone of trial after taking cognizance. Here, question is
It's the framing of charge.
Right.
It's proceeding.
Yes,
Charge has not been framed.
No.
Charge
Only the charge has been received. It reveals that charge sheet has been received on
309 will not operate here.
may not,
The
yes.
fact remains that you have shown me the Lokayukta order. Where is that page?
That is dated 9/2/2023 at page 134.
134.
That is the order of the High Court. The Lokayukta order is at page 64 operative person.
This is 13/1/2023. And the High Court order is once again
That is at page 134. 9/2/2023.
Yes, that is the last line is an interim measure.
Yes.
It is directed that there shall be no
effect. The order dated 13/1/2000.
Who is the vigilance counsel for me? Okay, I'll pass the order. Let him come. I understood it. I'll have to stay.
Yes.
Call him. You don't trouble him. I understood it. He may not argue. Call him. I'll pass the order immediately. At 2 o'clock. Call him at 2. Yes.
Item 9.
9.
May I please, Your Lordship? I am appearing on behalf of Mr. Biswal. Due to illness, he could not appear. Requested me to appear on his behalf.
Urgent.
No, I will proceed
yeah.
with the due
All
process.
right. Yes.
My lord, here the petitioner is challenging the impugned order dated 15/11/23. That is 311 petition. That has been rejected.
311.
My lord.
Yes. Which witness?
PW 1213, my lord.
1, 2, and 3. Why?
There are few questions left over, my lord.
Huh?
Few questions were left over. It could not be asked by the defense.
Why have you not asked? It's not a routine job. You get wiser, then thereafter you think, oh, this question should have been asked, so therefore move application. It's not that. That is not the idea of 311. Show me the reason why you have not examined and opportunity was given to you or not. If opportunity is given, then
my lord, the lower court have only rejected only on the
you
ground
have
that
sufficient
it was
opportunity to
delay.
lead. Yeah.
For the delay, they have rejected the petition, my lord.
No, not delay.
Where is that?
Page 37, last para.
Page
Lordship may
37.
kindly-
37.
Page 37, last para.
Impugn order is at page 37.
Page
My-
37.
37, my lord.
Last para, Lordship. Started from I have
Sorry.
already.
No. This is item number.
Item number 9. CRLMC 5164.
No, impugn order starts from 61.
No, 37. Page 37.
But it starts from 61. And it is okay.
I think my lord, your
Ah,
Lordship.
yes, okay.
37 is the reject
No. 30.
7.
30. Yes, 37.
Lordship got it?
The provision enraged under section
The
311.
last para is started from I have already.
No, this is something else.
Until the filed a full. Wrong.
How many annexures you have filed?
Annexure 4.
Annexure 4 is the order dated 15/11/2023.
15/11/23, that is the
That
rejection.
starts at page 61.
61 to 62.
You are
61 to
reading something else.
No, no, no.
Which paragraph you are talking about? You are reading from impugn order?
Yes, yes.
Yes, my lord.
Read it.
I am reading, Lord. I
Start.
have already heard both the sides.
1 minute, I'll just take it. I have already heard.
Both
that
the
is at-
sides.
See, that is at page 61.
Up to 37 is with me. No more pages are there.
Why conspicuously other documents are not supplied? Anyway, read it, sir.
My lord, I have already heard both the sides. Period the case record along with the evidence of PW 1, 2, and 3. It is found that the questions which are proposed to be put to the above said witnesses as per the questionnaires dated 7/11/2023 are already put to which the above said witnesses have already given answer to it vividly. Further, these questions as per the questionnaires to my mind are not essential for the just decision of the case and such are not the grounds to recall the above witnesses as per the section 311 of CRPC. So that he has gone.
Then your door is closed.
We should get a chance, my lord, at least.
No question of chance. Dekho, Learned Counsel for the petitioner has challenged the order dated 15/11/2023 passed by learned ad hoc additional decision sessions judge FTSC2 Kotak, whereby his application under section 311 CRPC seeking recall of witnesses 1, 3 and 1, 2 and 3
1, 2, and 3.
has been turned down. While turning down the prayer for recalling the witness, the learned trial court has recorded as under. Page 61, I have already heard both the sides. I have already heard both the sides. Provision and is not the ground to recall the above said witnesses as per section 311. ठीक है, सिर्फ paragraph मौजूद है, पूरा clear था. See, full step. The learned trial court has not only examined the relevancy of the proposed questions to be put to the witnesses, but also of the view that the application was filed in a very belated stage, therefore rightly rejected the application under section 311 moved by the petitioner. Next order. There is no infirmity in the impugn order, therefore this court is not entertaining this petition. Accordingly, it is rejected. Next.
Okay.
Yes, come.
Item 50.
1 minute.
Item 50.
In this case, you know, your mercy issued notice on 5th,
Yes.
but you received deferred the application to hear the application of the entry order. It is that case, my lord, where under the Mines Act, it is delayed 6 years limitation, and he says on 468, it is condoned.
No. That's
That's
service is complete.
No, service not completed. AD of notice but not to
Has
it is
not
not returned. Not returned.
So then we have to wait.
Another.
You tell me the date, then we will see.
And next week, any date, my lord?
Next week,
17th, 18th. It will take 1 minute.
let it be 19th. 19th, huh? 19th, sir. Okay.
Okay.
Thank you.
Well, I'm sorry, my lord.
No, it's all right. Rather, we are sorry that you made you wait. Okay.
Item 10.
On the ground of compromise, my lord, I have referred this application. And in the meantime, also the informant was appeared. And your lordship kept
What is
this-
the offense?
My lord, 342, 452, 387 and 34. Yesterday, one matter was there, your lordship kept it to 18 along with this application.
Let it come on it.
Yes. And in the meantime,
KRLM, number?
Say number.
only your lordship keep this matter because in that, say, Aroda filed an yesterday it was there, 40. Your lordship only keep this matter because in that case, order was passed.
Already.
Directed to appear with your lordship.
Which,
item 10, yesterday view item 10.
item 10 just.
সেই অর্ডারটা লেখা হয়েছে এই সিআরএল
6 to 18 one.
18
Item
Same order
10 item 10
10.
Same order, same order.
Same order
Same
করো 10 টা দেখো same order করো না এইটা দেখো and tag list along with that
40
401.
হ্যাঁ 40
same order করে কি list along with it. ঠিক আছে
180
চলো next
11.
yes
Petitioner challenging the order effect 21/6/2023 as improper and non-application of mine because no such transaction between the petitioner and the opposite party has ever happened.
what is this order
It is a 160 case, 138 NI Act. How cunningly this opposite party has done all these things. In the year 2020, Madam, kindly see paragraph 7 of my petition, page 5.
show me the complaint come to the complaint
Madam,
come to the complaint
my
at page 17. You are Raghunath Saraf.
yes, the complaint is filed with one Dandapani Sahu, who happens to be the proprietor of one Odisha sales, which deals in the accessories of Indian gas. Indian gas accessories means the gas burners, the hose pipes, regulators, and all the accessories. I am the gas dealer. I deal with the cylinders. I just distribute the cylinders. I am a distributor of cylinders. I have 20,000 customers under my institution. In the year 2020, there was a dispute between me and this Dandapani Sahu, in which this Dandapani Sahu was not the complainant. Taking the advantage, one so-called manager of this house, Odisha sales, he is Gyanaranjan Parida. He filed an application that some 10,89,000 some odd is pending with me, as we had a business since 2011. 2011, we continued up to 2019. Every transaction is completed, but since he has come up with a prayer to the learned court below that I owe 10,89,000 some odd rupees to him.
Right.
So under section 153(6), the learned court below SDGM Bhubaneswar directed to cause an inquiry by the police. The police visited, inventory was made to my office there at Tarva. The comes in the district of Sonpur, Tarva. They made inventory of my office. They seized some papers or documents, whatever it may be. They have never furnished me the scissor list of such documents. The clandestinely they have made all these things. While matter being such, and the matter was pending before the SDGM Bhubaneswar, invoking section 102 of CRPC, the police freezed my account, my bank account, which is operated as my business account of my agency. They freezed my account despite my deposit of rupees 5 lakh to them, because on 17th of January.
What is the relevancy of all these things in 138 matter?
My lord, I am coming. Because no such transaction as alleged in the present case, that 2 checks were bounced, for which he is claiming 7,89,000 against me. The transaction has never happened. I have not issued those checks to him. That I am.
How has it gone to his hand?
Yes, madam. The inventory that was made in the year 2020.
In that case.
Yes, in that case, they had procured some checks of my father and my checks fraudulently. My father's check was presented in 2021.
I have signed the check.
My father has my father.
Blank checks you have kept in.
Yes,
check.
in the table box.
Then presumption under 139.
Yes.
If you say it is stolen, unsigned check, they've signed for, then you have a defense. Otherwise, if you have signed in the check, blank check you have signed.
Blank check was kept in the drawer of the table.
Signed blank check
of my lord. I'm a gas agency.
Well, whichever agency you may
whenever I go outside,
you get the checkbook, all the checkbook you sign, keep in your drawer. Somebody comes and sees that they takes and
police had gone to my agency to make an inventory. But
in the check, do you have the signature or not?
Yes, my lord, I have the signature.
Then 139 operates against you. You have to face the trial.
My lord, I admit it. But another thing is there. We both are under the year of oil marketing company. We are the dealers under the Indian Oil Company. My lord, may kindly have a glance.
The only thing I can say that you are in a bad company. That's the only thing I can say.
Probably, my lord, because that case cannot stand the scrutiny of law, the earlier case, because
maybe what to do.
It was the case is of a civil nature, but invoking section 156(3), filing a complaint case, they proceeded against me.
Have you proceeded with this complainant? Filed complaint against him?
Yes, my lord, I had come up with another 482 in the year 2021, which was disposed of in 2022 by this honorable court, and the order I'll show to my lord. It placed at annexure 5, order dated 28/9/2022, page 26 and 29, page 26 to 29, my lord.
What does it say?
My lord, my lord, got the page 27, page 27 of my Kantanath Saraf. It happens to be my father. They claimed the amount of 5,89,961, which was deducted from that case, 10,89,961, which I have paid 5 lakhs to them. That check has been put to use in this case, and 138 was filed. It doesn't come under the purview of 138, my lord, because 138(1) says when a check is issued in due discharge of a debt or liability, where from my father's liability come. My father was not liable. My father was dragged into the proceeding just to satisfy his son's liability. And that is how this case has taken place. And the discharge petition is still pending in Bhubaneswar, my lord, in this court, in the learned court below. And when they realize that they cannot satisfy their grudge on me, in this time with those two unused checks, they have come with the new case of 138 against me. And my lord, you may kindly have a glance at from page 30 to 46, annexure 6, my lord. The Indian Oil manual I have given. My lord, I am ready to give him. I am ready to give him 7,90,000 here on this table if he satisfies that I have taken some. There must be some order. The placement of order must be there to procure the goods.
All these things are fantastic for the purpose of trial. That's what the the coordinate bench of the court
proceeded, my lord, illegally.
But the coordinate bench, I was reading that order only, which you have pointed out.
Yes.
The coordinate bench of this court, when your father has approached in this case,
yes,
has he said exactly the same thing which I am saying. Exactly the same thing which I am saying. All these things are very unfortunate that it has happened with you. But see, we have to go within the four corners of law.
My lord, kindly have a glance at
all the stories are
Indian Oil.
No.
Every transaction has to be.
I am not conducting a trial here.
My lord, I understand.
482, I will go to all the defense, whatever defense you have.
Well,
You're filing many documents.
Let him come and furnish a single document which would show that I had taken 7,90,000 goods from him. I have procured.
Your father's petition was dismissed.
But I was asked to file a discharge petition. They are
That you have a right. That doesn't mean that the court only says that you have a right to ask for a discharge. You have went for discharge. If it is now rejected, then you will come back. As if it was a direction to you. Fact remains that the criminal miss case filed by you has been, your father has been turned down. Very specifically, it is dismissed. And recording all your evidence, statement which you are saying.
Yes, ma'am.
Why are you prejudicing your client at this stage by inviting all observation from the High Court at this stage? Better that you should, I will expedite the trial. That's
But
the best thing.
I have already appeared in the court.
Appeared, but expedite, because see, looking into the way the complainant has dealt with you, he might have done it if your facts are correct. Then I expedite the trial and.
But whatever the transaction, it should reflect in the Indian Oil portal. Otherwise, the case cannot stand, my lord.
Do you want that I'll summon some Indian Oil to examine here?
No.
Then
No.
What do you want?
But the opposite party should be called on to show a single page of.
That will not help you in the sense. If I'll call, ask for reply and all, your trial will be stalled for some time, and eventually your petition will be dismissed. Then you are wasting your time. Better is I'll give a direction that to expedite the trial and get out of this problem.
Unnecessary.
Why?
Dragged into this
You have to
problem.
face the trial because you only because of the fact that so many facts are entangled in between.
It is my misfortune that
That's
I had
why-
transacted with a bad person. That is the thing.
What do you say?
But
Shall
unnecessarily I have been dragged into this.
Shall I simply dismiss, or you need something, or you withdraw? What do you want?
Directly the lower court to expedite the trial.
That's the best way, I think. That's the best way.
Unnecessarily I am
Right now,
put to trouble.
the petitioner is facing a trial for alleged offence under 138 NI Act in ICC case number 2915 of 2023, along with his father. Father, Mr.
Kantanath Saraf.
Kantanath Saraf. Seeking quashing of the proceeding. You also came.
My lord,
You also came.
may I 1 minute? The Dandapani Sahu was not the earlier complainant.
All these things will not cut any eyes, sir. Why are you wasting time? Quashing our proceeding. The co-accused, Mr. Kantanath Saraf, filed CRLMC 683 of 2022.
He was not a co-accused, my lord,
Then,
in that earlier case.
in this case, I am talking about 138.
In this case, he is not the accused. The accused is Raghunath Saraf,
And
the proprietor of the.
and why Kantanath Saraf has come?
Because in an earlier case under 138 NI Act, this said
No, the
Dandapani
same
Sahu had implicated my father, called on him to satisfy his son's liability.
Same defense.
Yes, my lord.
Same defense.
Son's liability.
No, first. Full stop. Offshoot of the dispute, the father of the petitioner was also entangled by the complainant in the instant case.
Complaint, no, opposite party.
Opposite party.
In this present case.
Opposite party of the complainant in this case. Full stop. I've heard the learned counsel for the petitioner at length. As per the narration of fact, the case has a checkered history. Full stop. The father of the petitioner, Kantanath Saraf, earlier opposed this court by filing CRLMC 683 of 2022. The coordinate bench of this court on 28/9/2022 has been pleased to pass the following order. Page 28, para 4. Para 4, 5 and 6. Good, sir. The present petitioner approached the trial court for discharging him from the complaint case. But he discharging, he found no favor from the relevant trial court. Therefore, has approached this court by invoking jurisdiction under 482 CRPC. The fact that he is contending, the counsel for the petitioner is contending that a serious fraud has been played by the complainant.
Opposite party. By the opposite party.
Complainant in your case, complainant of the opposite party, and the question checks were the seizure items in the connected case. Full stop. This court at this case stage, this court under the jurisdiction of 482 CRPC cannot enter into the fact-finding exercise. However, even if the facts so narrated by the petitioner is believed at the threshold, he needs to establish the same in the trial. The only indulgence that could be given at this stage by this court is to expedite the trial of the complaint case. Even otherwise, being an accused, the petitioner is entitled to a speedy trial. Next one. Keeping in view the peculiar facts of the present case, I am of the considered view that the trial court is directed to conclude the trial of the ICC case number 2635 of 2021, pending against the petitioner, as expeditiously as possible, preferably within a period of
2635, not matter.
Yes.
2915.
Huh?
In the present case, it is
2915. Sorry, 2915. 2915 of 2023, preferably within a period of 5 months hence. 5 months hence. The petitioner needs to cooperate with the trial without seeking unnecessary adjournment in the matter. With this observation, the petition is disposed of. Next. Come.
Item 12.
May I please?
Yes.
Madam, here NBW has been issued, page 14, man.
What is the offense?
Offense, my lord, 341, 324, 323, 307, 506.
Bail.
He was on bail on 3/3/2020.
20.
Madam,
NBW,
issued on 22/8/2023.
how many defaults?
My lord,
How
First.
many defaults?
First time, my lord. Yes.
First time report. Huh?
Yes, my lord.
How much? 500, 1000,
12 ମାସେ ଇଏ ହେଲା 8 ମାସେ
ହଁ?
20 ମାସ 20 months
20 months. ହେଲେ 1000 ଟଙ୍କା।
ହଁ 1000 ଟଙ୍କା ହେଲେ ହେଇଗଲା
1000 ଟଙ୍କା।
19 ବର୍ଷ ଛୁଆ
The petitioner is facing trial in GR case number 19 of
ବାର
2022 under section so and so so and so. The land council for petitioner submits that he has been enlarged on bail on 3/3/2020 in the present case. However, for a singular default in appearance before the court below on 22/8/2023, the trial court has issued NBW against him. Therefore, he seeks interference of this court. Good, sir. Having taken into consideration the facts and circumstances of the case, the impugn order dated 22/8/2023 is set aside, and the order of issuance of NBW against the petitioner is recalled. The petitioner is directed to surrender to the jurisdiction of the trial court and appear before the trial court as and when directed by the trial court. The petitioner is subjected to cost of rupees 1000 to be deposited with the welfare
fund of the Orissa High Court Bar Association.
by allowed. Next. I'll just come within 2 minutes.
Yes, yes, sir.
Thirty-six lakh 75,000 was awarded.
Hmm.
That is questioned in appeal. In the appeal, as per the amendment of 143 of NI Act, 20% is to be deposited. The court below directed 20%. I filed an application that it may be, time may be given and it may be installment may be fixed. That he has rejected. I'm not questioning 143.8 capacity. He has the power under 20. It is always prospective. That I had argued before another collateral bench where it is prospective or retrospective. Here that not in dispute. I only pray he has directed to pay 7,35,000. I only pray your lordship may fix it installment. I am ready to pay it. This is the only point in this.
Can I do that?
Yes, your lordship has.
143, they just seek to.
20% is there. 20% not in dispute. 20% is there. But the amount which is to be paid, your lordship will not interfere on that 20% quantum. I am not questioning that. I only pray that it may be installment may be fixed. I had prayed before the court below. Court below only granted me 60 days. I only pray installment and some more relaxation in time in paying the money. I am not questioning that.
No, 60 days I can extend, but breaking that 20% is not permissible, but the statute says it's 20%.
No, statute says 20%. I am not asking.
I will extend the time. You keep the installment deposit somewhere. When it is 20% deposit.
No, that is the trouble.
But
that is the trouble I'm facing. 7,35,000 is difficult for him to. I am not questioning that 20% he will not pay. I am not requesting your lordship to interfere in that.
143 just see. So
yes, 143.
NIA.
20% is there. 20%. That is not in dispute.
So that I can't break. The statute says 23%, 20% means 20%.
20% means 20%.
But
he is not on that. He is praying to extend the time and installment.
Time and installment, both.
Time I can think of, no installment. Time I can think of. 143.
Up to 20% is there. Not when fixed 20%. Up to 20%.
143.
A.
Capital A. Follow the code. Now. A, which provision?
43, the amending act came on
That's right, but this is
month of August 2018.
No, that's right. But in the appeal, where is the provision?
Appeal, my lord, there is no.
Interim compensation shall be paid within 60 days from the date of the order. And summary trial or summon case where it's guilty. Where in the appeal after conviction? 143. 143 is an interim compensation.
Yes, but not in appeal.
It's like in a money decree now.
Yes.
Because you suffered a summary trial. And now the order is passed. The award is there, whatever. It is 7 lakhs, huh?
7 lakhs, 35,000.
What is the
37 lakhs.
37 lakhs.
37 lakhs.
And it comes to 7 lakhs, 20%.
7 lakhs, 35.
But you take out 143 capital. Where is the
148 was also amended, saying that the appellate court to pass an order pending appeal to direct appellant accused to deposit a sum of rupees not less than 20% of fine or compensation. 20% I don't dispute. Question is, my lord, that
can I break 20%? Installment means 20%. Power of appellate court.
Yes. In 482, your lordship, seeing the situation, can do so.
Within 60 days.
Yes.
From the date of the order. Or within such period not exceeding 30 days, age may be directed. The appellate court may direct the release of the amount provided that the appellate court is executed. See, the statute also provides the time. 148(2) time is also provided.
correct.
20% is provided. And allowing you for installment means of extending time also. Time can't be extended because the statute is bound by the time period.
Your
60
lordship,
days and 30 days.
your lordship is correct. I don't dispute it.
Are you going to settle this dispute?
It can be settled. It can be settled.
I will not say anything, simply issue notice, let us see. Issue notice to the opposite party number, opposite party number 2. Returnable within 1 week, least it. Let us see if it comes, then If some settlement takes place, 138, you can take money and finish it up.
But one thing will be staring at. If I don't deposit, warrants will be issued. My bail bond will be cancelled.
We simply say that I have the 482 court has taken.
Yes, the Lord, you said no coercive action. No,
No,
coercive.
because this court doesn't.
I am aware of my Lord's view, but my Lord,
482s are not meant. I'll try to find out a way so that things are settled, so that will come out of this problem in the larger conspectus.
my Lord, correct.
Not that in the indirect way, see the statute stare on the face of record.
No, my Lord.
I can't go beyond the statute.
I don't say, but here if my bail bond is concerned, I'll be taken behind bars. That is the trouble.
Learned counsel for the Mr. Bose, learned counsel for the petitioner submits that he apprehends that coercive action may be taken by the appellate court. No, but the trial court.
No.
Court below.
Additional session judge.
Court below.
Judge.
Court below. And he submits that he would be making appropriate prayer before the court to take lenient court below appropriate. He will make appropriate prayer before the court below, seeking an adjournment in lieu of the fact that the present this court has issued notice to the petitioner, opposite party number 2 in the instant case. 29th. Serve immediately.
Yes, madam. I'll take step on Monday itself. Because today, Monday I'll take.
This idea of issuing notice is only to explore the possibility of a settlement.
Yes.
Item 40.
It's a case of compromise. Here is the mallet. I have filed.
Steps like Tuesday because Monday is holiday.
Learned counsel for the Mr. Bose undertakes to take steps to serve the opposite party number 2 by Tuesday, by 17th. Yes.
Mallet, here is the one petitioner, mallet. So far as the accused persons are 3. Mallet, since the petitioner is working as a mallet junior engineer in Talavera mines, and the complainant is employee of that company, mallet, the dispute between both the parties, and the son and nephew not filed before your lordships. Mallet, I will mallet take adjournment. Mallet, the son and the.
You want to join son and they also co-accused. That's what is the offense? What is the offense?
307.
Oh, who is the victim?
Victim is my learned friend is appearing, Subhrakanta. I injured report.
No, Subhrakanta Samalo. He is the victim and informant also.
Yes.
Informant, who is the informant?
Yes, informant come victim.
Come victim.
You are appearing.
My security guard.
Where have you received the injury?
On the
Which part of your body?
My lord, I filed the injury report. 3 injuries, my lord. One is abrasion, swelling. 3 injuries.
Swelling and the major one you tell.
Major one, my lord, on the skull, middle finger. Swelling. Number 2.
What have you used?
My lord, I am not used to once Rajadas pelting a stone on the.
Rajadas is also an accused.
No, Rajadas.
What is the doctor says simple?
Yes.
Simple injury.
Above injuries are of simple in nature, may be caused due to hard and blunt weapon with other.
Already filed the injury, certified copy.
You file it, huh?
My lord.
You file it and do what?
Already filed. Already filed. That has been.
Okay, you want to join this 2 other.
My lord.
Learned counsel for the petitioner submits that the parties have settled the dispute, and although the informant opposite party number 2 who is injured by the petitioner and the co-accused persons have have received simple injury as per the medical documents, but the prosecution has invoked 307 IPC. Since the parties have now settled the dispute, on the basis of the settlement, he seeks quashment of the criminal prosecution. However, the other co-accused persons have not joined the petition. Therefore, he seeks time to make the other co-accused person co-petitioners. The prayer is allowed, matter is adjourned, with liberty to the petitioner to amend the memo of parties, and the parties are also directed to present before this court on the next date of hearing, least on 29th.
Item 15.
Please, Your Lordship. A petitioner filed the application for quashing the order of charge matter. In the meantime, now the matter is settled between the parties. I will issue notice to the opposite party.
Who is what is the offense?
Offense 420, 294,
420, blah, blah, okay. Okay. The petitioner is facing, what is the stage of the charge is framed?
Charge already framed, my lord.
Charge is framed. but
Instead of filing revision, it has
the
compromise.
offenses are 420. The petitioner is facing trial in ST case number so and so. देख लेना कोई. Where is that ST case? GR case number 1063 of 2021. Pending before the court of SDJM Talcher. Under section so and so. 420, 294, 506, 34 IPC. The learned counsel for the petitioner submits that he has settled the dispute with the opposite party number 2. On the basis of the said settlement, he seeks interference of this court for quashing up the criminal prosecution lodged against him. Let notice be served on opposite party number 2. Mr. So-and-so will notice for the opposite party number 1 stay, retainable. So the parties are at liberty to file joint affidavit, on the next date of hearing. They do short date, first week. First February.
Item 16.
Well, I'm seeking some small adjournment.
Yeah.
Small adjournment.
Adjournment.
Next.
Small or big, we will decide. Adjournment.
Next week, it may come.
Adjournment.
Item 17.
There is some defect. I have to remove it, sir.
Learned counsel for the petitioner seeks time to simply simply adjourn. Yes.
Item 18.
Please, Your Lordship. My Lord, in this application, petitioner was praying before Your Lordship to quash the order of cognizance as well as the entire criminal proceeding. Both petitioner and opposite party number 2 known to each other. Because of misunderstanding, case initiated.
Now there is an understanding.
Yes, my Lord. Already matter settled, even if one earlier application of
what was the offense?
Offense 376, my Lord. Both are married.
Now married.
Known to no.
Separately
married person. Opposite married lady. Opposite party number 2 is the married lady. Petitioner is the married person.
164 recorded.
164 recorded. In the meantime, settled. Thereafter, communicated to the investigating agency. But investigating agency submitted charge sheet. In the meantime, Lord and Magistrate 2 cognizance, I am praying before Your Lordship to pass the order of cognizance.
At the time of the offense, they were married.
My Lord.
Time of offense also they were married.
Before, yes, my Lord.
Both of them were married.
Married. They are known to each other.
The petitioner is seeking indulgence of this court under section 482 CRPC for quashing of the order of cognizance dated 4/10/2019 passed by SDJM so Khurda so and so. Okay? Page 5 prayer page so and so. So under section so and so. He submits that the learned counsel for the petitioner submits that the parties have now settled the dispute full stop. The allegation against the petitioner is that he has committed rape on the opposite party number. No, don't write like that. As per allegation, who is the informant? Opposite party number 2.
My lord,
As per the complaint of the opposite party number 2, the LA charge against the 376 IPC has been foisted against the petitioner. The petitioner and the opposite party number 2 were acquaintances, and by the time the offense has taken place, both of them were both of them are married individuals leading their respective life. Now they have settled their disputes, and the opposite party number 2 doesn't want to proceed with the matter. Full stop. Taking into consideration the submission made by the petitioner, issue notice to the opposite party number 2. Opposite party number 2 return within 1 week. The parties shall appear before this court in the next date of hearing. First week, 6th February.
May I pray? What IA is here, my lord. May I pray not to take?
What is the stage of trial?
Just after filing of.
Then nothing will happen.
Commitment है नहीं.
Nothing will happen.
No commitment made.
May I pray one?
Commitment till it not made.
Commit may है नहीं. Why do you worry?
Organized stage काय करी?
Appearance, no, someone already issued.
Maybe.
May I pray? My lord? On 376.
I know once I'll say, then the next time you will get it. I know that. No question. Bring her. If you can bring little early also, I am ready.
Sorry, my lord, I did not stay. May I pray before your lordship on filing of a 376 petition, may allow by the law and court below till disposal of my CRLMC before your.
Oh no shortcut. Come, bring her and we'll finish it up.
Yes. Obliged.
In the meantime, I also is. CD and CS 164 I will also come from there. Case diary will be.
They were married. Why unnecessary? 164. 164 assume importance if a POXO is there. Otherwise, here.
Obliged.
Next.
Item 19, my lord. The offense under section 498A, 323, 506, 34 IPC and 4 DPI.
Yes.
The matter already settled between the parties.
Who are they? Where are they?
13B already filed and disposed of on dated 19/7/23. And she has
13B.
Mutual divorce.
What is the permanent alimony?
7 lakhs already received.
And what other cases?
Only this case, GR case.
No other case.
No other case.
Notice was issued.
No notice. First.
I have been instructed to active in this case on behalf of wife. Today I'll file the affidavit.
Mm-hmm.
And the affidavit. Instruction, no notice has been issued.
He says something, you are trying to stop him.
Affidavit to file by the wife.
You want to file affidavit? What? Regarding settlement has taken place. To file, we issue the counsel for the petition, by way of this petition, the petitioner seeks quashing of criminal prosecution in Mahila PS case number 142 of 2022, corresponding to so-and-so under section so-and-so. This is a this proceeding is arising out of a matrimonial discord. The parties have now settled their dispute. And as per the settlement terms, petition under section 13B was also moved before court below, and the marriage is dissolved by mutual consent. the petitioner seeks quashing of the pending criminal case against him. Issue notice to the opposite party number 2. Opposite petitioners, there are many petitioners. Opposite party number 2, returnable within 1 week. Short date they start. Bring them and finish.
The date fixed for personal appearance both the parties.
What is the stage of trial?
Trial for a charge, for appearance of the accused after charging.
Having taken into consideration the aforementioned facts and circumstances, the proceeding before the court of which court?
SDGM.
You have not moved application also. You have not moved the application. There is no application.
No, my lord, he is praying for appearance of both the parties before your lordship.
Not state.
Not state.
Record there. Like I have already said, the parties to appear on the next date of hearing.
Yes, Lord.
Parties to appear. Yes. Okay. Second Feb. Bring them and finish. Next.
Item 20.
May I please your last word? Here in this case, my lord, present petitioner are so-called father-in-law, so no, excluding court marriage, no other marriage is there. I have annexed the FIR. You also kindly have a glance the FIR. What is the allegation against the present two petitioners?
Dwarka Prasad, Bimla Kumari Das, Chinmay Pradhan. Chinmay Pradhan is the
As per informant of the case, my lord, as per allegation,
you say your son is not married.
No, husband. So for marriage, that is court marriage is there, my lord.
Why do you use the expression so-called?
So-called means, my lord, that you also kind of glance.
You don't recognize their marriage.
Yes, my lord. Court marriage is there, my lord. So for pattern custom, Saptavati marriage, that has not been done. You also kind of, there is a law of affairs initially. After the law of affairs, they have physical relationship. Due to that, she conceived and it was aborted. Her allegation is that at the consent of the petitioners were there and aborted. I have annexed the doctor here. The doctor also said no such abortion is there in the hospital. So she kind of glanced the affair. As per you also know the Supreme Court decision matter, the allegations are how 498 allegations are there, madam. So I have based 20 the affair, madam. It is not based 20.
That at the time one Anshuman Satpathy.
2006 ମସିହା ପୁରା ପ୍ଲସ୍ ଟୁ ସାଇନ୍ସ ପଢିବା ସମୟରେ ଭଞ୍ଜନଗରରେ ନିବାସୀ ଦ୍ୱାରିକା ପ୍ରସାଦଙ୍କର ପୁଅ ଅଂଶୁମାନ ଶତପଥୀ ମୋର ସହପାଠୀ ହୋଇଥିବା ହେତୁ ଆମ ଦୁଇଙ୍କ ମଧ୍ୟରେ ଲଭ୍ ଆଫେୟାର ଗଢି ଉଠିଥିଲା। 2009 ଠାରୁ 2014 ମଧ୍ୟରେ ଦୁଇଙ୍କର ବ୍ରହ୍ମପୁର ଠାରେ ମିଶିକିରି BCA ଏବଂ MBA କରୁଥିଲୁ। 2011 ମସିହାରେ ଅଂଶୁମାନ ମୋତେ ବିବାହ କରିବାକୁ ପ୍ରଲୋଭନ ଦେଖାଇ ମୋ ସହିତ ଅଶ୍ଳୀଳ ଭିଡିଓ ଏବଂ ମୋ ସହିତ ଶାରୀରିକ ସମ୍ପର୍କ ରଖିଥିଲେ। ଆମେ ଅନ୍ତରଙ୍ଗ ମୂତ୍ର ଭିଡିଓ ତାଙ୍କ ସହିତ ଅଛି, ଫଳରେ ସାମାଜିକ ସ୍ୱୀକୃତିରେ ଆମ ଘରକୁ ବୋହୂ କରିକି ନେବୁ କହିଲୁ। 2021 ମସିହା CRP ରେ ସ୍ଥିତ ଭଡାଘରେ ଦୁହେଁ ମିଶିକି ରହିଥିଲୁ ଏବଂ ଅଂଶୁମାନ ଭଞ୍ଜନଗର ଠାରେ ରେଷ୍ଟୁରାଣ୍ଟ କରିବା ହେତୁ ଉଭୟଙ୍କର ପକ୍ଷକୁ ଉପଯୁକ୍ତ ସମୟ ଦେଇପାରୁନାହାନ୍ତି କହିବାରୁ ଭଞ୍ଜନଗର ଠାରେ ରହିବାକୁ ମନସ୍ଥ କଲୁ। ଉଭୟ ଆଲୋଚନା ପରେ 20 ଜାନୁଆରୀ 2022 କୁ ବିବାହ ସ୍ଥିର ହୋଇଥିଲା। ଅଂଶୁମାନଙ୍କ ପରିବାରର ସ୍ୱାସ୍ଥ୍ୟଗତ ସମସ୍ୟା ଦେଖାଇ 15 ମାର୍ଚ୍ଚ 2022 ବିବାହ ସ୍ଥଗିତ ରଖାଯାଇଥିଲା। ଆମର ଗୁଆ ଅନୁକୂଳ ସତ୍ତ୍ୱେ 7 ନଭେମ୍ବର 2022 ଦ୍ୱିପହର ସମୟରେ ଅଂଶୁମାନର ପିତା ମାତା ଆଉ ଡକ୍ଟର ସାଙ୍ଗ ଆମ ଘରକୁ ଆସି ବିବାହ ବନ୍ଦ କରିବାକୁ କହିଥିଲେ। ଅଂଶୁମାନର ବାପା ମୋ ବାପାଙ୍କୁ କହିଲେ କି ଆପଣଙ୍କ ଜାତି ତୋଷା ଆମ ଜାତିର ବ୍ରାହ୍ମଣ, ଆମ ଗାଁରେ ତୋଷା ମାନଙ୍କ ବ୍ରାହ୍ମଣଙ୍କ ପାତ୍ର ବସନ୍ତି, ତେଣୁ ଆମେମାନେ ଆପଣଙ୍କ ଝିଅକୁ ବୋହୂ କରିବୁ ନାହିଁ, ଛାଡ଼ପତ୍ର କରାଇ ଅନ୍ୟତ୍ର କରିଦେବୁ। 8 ମାର୍ଚ୍ଚରେ ସମସ୍ତ ନିତ୍ୟ ବ୍ୟବହାର୍ଯ୍ୟ ଜିନିଷ ପତ୍ର ସହ ଅଂଶୁମାନଙ୍କ ଘରେ ରହିବାକୁ ଭଞ୍ଜନଗର ଯାଇଥିଲି, କିନ୍ତୁ ଅଂଶୁମାନ ତାଙ୍କ ଘରକୁ ନ ନେଇ ମେଡିକାଲ ଷ୍ଟୋରକୁ ନେଇଥିଲେ। ପିତାମାତା କହିଲେ କି ତୁମ ଦିଦି କହି ଆମ ଘରକୁ ଆସିଲେ କଣିକ ଘାଟିକୁ ନେଇ ମାରିଦେବୁ, ଫୋପାଡ଼ି ଦେବୁ। ଡାକ୍ତର ସାବତ ଉଚ୍ଚ ଶିକ୍ଷିତ ସତ୍ତ୍ୱେ ମୋତେ ଅଂଶୁମାନ ରଖିବ ନାହିଁ କି ବୋଲି ସଂଶୋଧନ କରି ଖରାପ ଭାଷା ଲଗାଇ ଗାଳି ଗୁଲଜ କରିଥିଲେ। ଏମିତିକି ଇଞ୍ଜେକ୍ସନ ଦେଇ ମାରିଦେଲେ। ହାର୍ଟ କରେଇଦେବ ବୋଲି କହି ମତେ ଭଞ୍ଜନଗରରେ ଜବରଦସ୍ତି ଆମ ଗାଁରେ ଆଣି ଛାଡ଼ିଦେଲେ. This is the allegation so far. This Anshuman and this person are concerned.
There is allegation against Anshuman only. There is no allegation against.
So far, above so far 313 is concerned. You kindly have that page 51. I have analyzed the statement of the doctor. The doctor very specifically stated no such abortion has been done in that eye hospital matter. That is the only 6 witnesses examined in this case matter. Victim and her parents. I have analyzed the evidence of parents. Parents' evidence is this type of allegation are not there in the evidence of parents' matter. And 3 other witnesses, 1 doctor and 2 independent witnesses. All 3 of these witnesses are not supporting the prosecution case. The other 2 witnesses stated they are living well in though they are living separately. When Anshuman and this Chinmay, they are living separately and living happily. These 2 witnesses they have specifically stated. Only 6 witnesses out of these 2 witnesses and doctor, excluding that the victim and her parents. On this basis, this petitioner are facing trial, 7 years old man. And the allegation is that the omnibus allegation, as his friends are also that doctor and
The only specific allegation is the abortion part.
Abortion is also jointly along with Anshuman, and no such abortion has been taken place as per evidence of page 51. That is no such abortion. Sisma circle that doctor evidence.
Yes, Mr. Raghuda, I think it is the entanglement. Only to pressurize.
First time listed, my lord.
The Anshuman might have done whatever.
My lord.
The old parents.
That my lord, all the 162 not with me, my lord. Case diary required in this case, my lord. Case diary required, my lord.
Bring the case diary.
My lord.
Watch it.
My lord.
Against these old people, 70 years and 65 years. And the son has done so many things.
Well, case diary will come.
Let the son face the trial.
If my lord the case diary is not found, my lord, then it was passed.
Issue notice to opposite party number 2. And Mr. Raghuda waives notice insofar as opposite party number 1 is concerned. And 6 time to bring place on record the case diary. What is the stage of trial?
Charge has been I have challenged the order of charge.
Have you moved an application?
No.
Having taken into consideration the allegation against the petitioners and perused the 161 statement of all the accused person. I am of the view that by way of interim order, the trial vis-a-vis these 2 petitioners is stayed.
Another 2 petitioners are also there. That is those friends, my lord. These are those trial.
No, there are 2 petitioners only. There are 2.
No, out of 3209.
That is not there. Then jab aayega dekho. Who are these petitioners? They, vis-a-vis these petitioners. Who all are they? The other 2 people? Friends.
Friends. So friends are like doctor out
Sabat, Dr. Sabat.
Those 2 petitioners there.
Whenever it will come, we'll see. You don't complicate your case because of them. If the Sabat and everybody is there, then see 120B and all are there, then your case is wrong.
Well, urgent to.
Oh, second week, 16th.
16th.
No, make it 20th February.
20th.
Item 21.
On behalf of Mr. Anuruddh Das, praying for an adjournment.
22.
My lord, I am praying adjournment I am submitting on behalf of Satyapada Sharma, who has gone through his note.
Next.
24.
Pass over.
25.
May I please before your lordship? I am appearing on behalf of my senior counsel. Sir, I am appearing on behalf
What
of.
adjournment?
No, sir, it is there is a defect.
Cure the defect.
And remove it.
You want to clear the defect? Cure the defect. Okay. Next.
26.
Much obliged.
Thank you, Your Lord.
Yes.
That the petition was challenging the cognizance order, my lord. The Lord and Magistrate taking cognizance under section 147, 148, 351, 294, 307, 323, 324, 506, and 149 IPC, my lord. My lord, there is no injury and all the injuries are simple in nature, my lord.
147, 148.
Mechanically.
Simple injury, therefore, to 323.
Yes, my lord. The 307 is there, my lord.
Where is the cognizance order? Doesn't say
Yes.
307. That is the cognizance order dated 18/6/2019.
My lord.
And just see, there is a prima facie, let us read it. So and so IPC against the accused. Who are you? Bhagwan. What is your name? Bhagwan Das. Umakant Ponda. Praful Ponayana. 1 minute.
Bhagwan Das along with 6 others.
Bhagwan Das, Umakant Ponda, Praful Das, Das, received. There is the. You read 18/6/2016, 19 order. Read.
Charge sheet number 56, dated 22/5/2019, under section 147, 148, 3.
All the provisions, okay, IPC. Where 307 is there. Okay.
307, 323, 506, 149 IPC against the accused Bhagwan Das, Umakanta Panda, Abhiram Das, Prafula Das, Sarveswar Mahapatra, Dhiren Kumar Das.
Is received.
My lord, is
okay.
received.
Thereafter you read.
Peruse
the same.
Found
There is a prima facie material.
Hence, cognizance of offense under
Cognizance of offense. Now read. Cognizance of offense 148, 147, 148, 341, 323, 506, and 149 is taken. Where is 307?
My lord, my lord. My lord.
You have not read the cognizance order. You want 307 to be added? I read it. Edit.
No, my lord. I'm sorry, my lord. On that point, I am sorry. I'm sorry, my lord.
Simply withdraw. Otherwise, I'll edit.
Exactly.
It says the charge sheet is filed in 307, but cognizance is not taken in 307.
My lord, my lord.
You should be happy in this order.
Yes, my lord. I am
not ready. Simply withdraw.
My lord.
Withdraw. Okay. She might have thought in the first 2 lines, but it is only received.
The main thing, my lord, out of court, the file just handed over to me.
Then. 27. Do you have any other point? You withdraw, then again you come and mention it. You have no problem, except 307 was the only.
Exactly, my lord, page 30, I will want to place before your lordship.
Not necessary because
already mentioned the injury are simple. You know, instead of 307, 294 not applicable.
The trial court was very careful about. Simple, that is 323.
It is mentioned instead of 307, 294.
Anyway.
The 294 deleted instead of 307.
Okay. Anything missing? No, nothing is missing. Okay.
27.
Yes.
May I please, your lordship? Your lordship, I want VC more. Your lordship, the petitioner Indira Dutt, who is a widow lady, challenged the FIR number 202/2022 pending at SDJM Bhubaneswar. Your lordship, this FIR is pure, the facts and the contents are purely in civil in nature, actually. Your lordship, the fact is.
My lord, he made the opposite matter 2, my lord. The SDJ made as opposite matter 2. How can, my lord, the court will be? SDJ? SDJ Bhubaneswar. Court cannot be fighting, my lord.
Where is that?
Interestingly. Page 1, first page.
Page 1. State of Orissa, HCGM Bhubaneswar, DG, Prime Minister, he left Prime Minister only. Except everybody. You have seen your petition? If a court passes an order, you make the court as a party, huh?
Your Lordship, actually, I am. This is my second case at the High Court.
But you amend this MUA parties. What
Your
DG police will do? You have implemented state. What SDGM will do? You amend the petition.
Your Lordship.
Land Council for the petition seeks time to amend the petition. Urgent. Next, 28. Amend the petition. We'll give it
28.
Lordships, item number 28, I pray for some time to take instruction.
Instruction regarding?
The case is whether it is pending or it has been disposed of, because the order which I'm challenging is of 2021. The cases of the year 2020.
Framing charge in 2022.
22. So I just need to take some instructions. It has been left out. I've just put it.
I will simply urgent.
Lordships.
Why and
Lordships.
29.
waiting for a happy news that it is done.
It is So I didn't get the opinion instead.
29 related come, it's a 1 week after.
29.
The matter has been compromised.
29 copy maybe, sir.
Yes, I will sort.
Compromise. What is the offense? Compromise then short date. No.
376. On the POXO Act also is there, but in the meantime, the girl has married elsewhere. She doesn't want to proceed in this case.
She will not decide. See, 164 statement, if she has made, the offense has already been committed.
So let it come.
Let it come its own.
1 week.
Item 30.
Copy maybe, sir.
Copy, give, supply a copy.
Oh, ये private party, yes, sir.
That's it.
Today,
आपको
Yes.
copy टा दे देंगे.
Yes.
May I please ask, madam?
Yes.
Now, married women are armed with the 3 weapons, madam. One Domestic Violence Act, 125 CRPC, and another 490 case. This is the glaring example, madam. The main allegation is against her husband, but she has made all the in-laws party domestic violence. Space 17, madam.
You are staying in your house where the in-laws were staying.
Left, madam. Allegation, I am reading, madam. Page 17.
Page 17 is
Last
the.
5 line, madam.
What is this? 17 is.
Page 17 is the.
Where is the FIR?
FIR, it is a domestic violence case, madam.
Achha, complaint.
Yes. Page 17 main allegation. Madam, before.
17 is the order.
Yes, yes.
Where is the complaint copy?
Her allegation is there, madam.
Complaint copy.
Is not with me, madam.
File complaint copy.
I am challenging the execution order.
No, but you, I need to see the what do you call?
But that part is reflected, madam.
Court might have picked up some paragraph. The entire copy has to be seen. That's the their minimum. Execution, there is an order. What is the order? 31 order.
The execution, we are.
No, is the order under 31?
NBW order was issued against us, madam. We filed a petition for recalling that. But Lord and Magistrate refused it since he has no.
Then it was so urgent, then you have to file all the documents. With
Yes.
2 weeks hence.
Yes, or that time.
2 weeks hence, he will file all documents. Yes.
Next week. Everyone next week.
Next week may not be possible. Next week. 1st, 2nd February. 2nd February. Very difficult because we have adjusted.
Some ladies, they are.
Then you should have been careful, na? You should be careful, na? Anyway, next.
May I please, your lordship, I may kindly permitted virtual mode, please. My lord,
Yes,
the
yes.
31, 32, and 33, some defects are there. Kindly 2 weeks time may be allowed for removal.
31, 32, 33.
Yes, my lord.
Chalo, de do ya.
Obliged.
34.
May I please, your lordship?
Yes.
Purely civil dispute, your lordship. Page 10, first one to 156.3. The police has registered the FIR. Challenging that, I before your lordship, questioning the same is purely civil in dispute, monetary transactions, civil in dispute. Why I am submitting that?
Charge sheet filed?
My lord?
Charge sheet filed?
Charge sheet not yet filed.
It is.
On plain reading of the complaint.
It is arising out of 156.3.
156.
Okay.
Civil suits are pending. Annexure 2, my lord.
What is the stage of investigation? Mr. Maharaj?
I'll get the CD, but I don't know. Because this document does not reflects any kind of information over investigation
What is
participants.
the allegation?
Allegation is, my lord, I introduced someone who had some business transactions with the complainant.
Okay.
The allegation you also could find.
Page 13, 1-3.
Page 13. No, sorry. I am being inducted as the tenant by opposite party number by accused number 3 to 10 in the complaint petition. I am the tenant there. And now, in absence of the complainant, I am placing that also. The accused number 5 to 10 are the immediate neighbors of the complainant. And they purchased land.
You are Pramod Patro and Rasmita Patro.
I am. 1 and 2. We are 1 and 2.
Pradeep Kumar Das is the informant.
Informant.
Now let us come.
Now, my lord, that the accused, per paragraph 3, page 13, the accused number 5 to 10 are the immediate neighbors of the complainant.
Where are you reading?
Page 13, your lordship.
13, okay.
My lord, finds it.
Yes, para 7, huh?
Para 3, my lord.
Para
3. Unnumbered para.
Unnumbered para,
Text
yes.
of the case. That the accused number 5 to 10 are the immediate neighbors of the complainant and their purchased lands are adjacent to the land of the complainant. But surprisingly, in absence of the complainant, these accused persons bearing serial number 5 to 10 have forcibly constructed some outhouse over the land of the complainant, and for that the complainant has already filed a suit bearing such and such for their eviction before the landed civil judge, Junior Division, Bhubaneswar. That meanwhile, having their ulterior motive and to grab the property of the complainant illegally and forcibly, the accused number 5 to 10 have kept the accused number 1 and 2 as tenants.
How are you related to 5 and 10?
Not related in any manner.
Okay.
Not related. In fact, my
tenant in the illegal and constructed house.
Yeah.
I understood it now. There was some dispute regarding this property. There was some illegal construction. In that constructed area, you have been inducted as a tenant.
That is the allegation.
That's the allegation.
Suit is pending. Suit is filed by Pramod Patra.
Against this 5 to 10.
5 to 10. No, against Pradeep Das. Pramod Patra is myself. I have filed it against the informant, against the complainant.
Okay.
That suit is at page 18. Status quo order is there, my lord. That you are also going to find at page.
You are Pramod Patra. You are the
inducted tenant as per the allegation.
You are accused number 5.
Nice, sir. Muheli accused number 1.
Why have you filed the suit then?
Suit filed because it is my land, my property. I have constructed.
Then that's the problem. You have not. You are the tenant.
That is the allegation that I have been inducted.
But you are not the tenant.
No.
You are the owner.
I am the owner. Consolation money has passed.
The fraudulent agreement has been made with the accused number 1.
I understood now. Complication.
Now, interim order is there. Status quo is prevailing, my lord. Page 30.
Wait till the charge sheet is filed.
Let him take instruction also. Let him take instructions.
You seek instruction, I will not issue you a notice.
Yes, I will take instruction.
Because there is something. She says that tenant, you file a suit. If you have no interest, why have you filed a suit?
But the allegation.
And a suit is a collusive suit.
Collusive with whom, my lord?
You have created a false document.
Yes.
That's the allegation.
And that is not the subject matter.
All these things require investigation at least.
My lord,
let us see what comes out in the.
Your lordship is right, but that's what he says. The fraudulent document is not the subject matter of the FIR.
That's a part of investigation. Now let us see.
My lord, civil suit is pending.
Since issue notice to opposite party number 1 to begin with. I am not issuing notice. Is there any chance of settlement?
He should come forward for a settlement, man. He has also filed a suit. So page 31.
Okay, issue notice to the opposite parties. Mr. Maharaj waives notice, and he seeks time to file seeking instructions regarding the stage of investigation.
Yes.
Urgent.
Your Lordship is fixing a date.
Third.
22nd.
February.
35.
And this is that introduction part I was saying. This is again 156 3 also. I'm taking your Lordship to the allegation at hand. In the constitution, my name is your Lordship, page 10, serial 6, Sujit Kumar Padya.
Yes.
Now, my Lord, the complaint is under section 405, 415, 416, 425, 420.
What is the stage of trial? You have
Just recently the FIR has been registered 7/8/2023.
This is again.
FIR registered 7/8/2023.
This stage you are coming.
My role is, my Lord.
Maybe role will be investigated.
It will be.
Let him come with instruction.
No. I will not
What
do it.
instruction?
You either withdraw or
why I
no
am submitting
question.
on plain reading
August
of the FIR.
2023 FIR is
7/8/23.
the moment FIR is registered, watching is filed. What is this?
My Lord, what I am submitting, your Lordship, plain reading of the FIR, your Lordship.
Maybe.
No case is made out against.
You are reading plainly, but they will not read so plainly.
Your Lordship,
As you like.
that is the power is vested in your Lordship.
Land Council for the petitioner seeks to withdraw this petition, wherein he has sought quashing of the FIR registered on 7/8/2023. Since the investigation is at the threshold, this petition is premature, as such not entertainable under section 480.
Premature.
That's what I'm saying, premature. After charge sheet, you can file it. If I'll not use that expression, it will create problem for you. It is premature only at this stage. It will help you rather this observation to again file a 482.
98 to Supreme Court, my Lord, 604.
It's no problem, premature at this stage.
But that is what your Lordship that says on plain reading of the FIR.
No.
Of course, if no case is made out.
Plain reading of FIR question comes once it, investigation is done.
Nice, sir. I don't agree.
Plain reading of FIR, if cognizable offence is made out, then it will be taken into, once the FIR has been registered, it's a cognizable case.
Then
So
immediately FIR
what matters will be available, then it is course of investigation.
At that stage. Then the investigating agency is redundant.
My Lord, if
and in the same time, Supreme Court also says that FIR is not encyclopedia.
Yes.
It has to be.
There is also a, my Lord, arbitration clause here.
I believe the police is also intelligent enough. They will file a final report.
You will see.
Final report.
Your Lordship would be seeing many a police reports which your Lordship won't inclined to accept. Anyway, no, I am not.
It would be a very good case that they may file a final report, otherwise challenge it. And if there is an arbitration clause, why have you not invoked so far?
With a criminal case, sir, I have to take.
You invoke it and tell immediately give 11 notice.
Then again, arbitration clause doesn't say me. This will proceed independently.
That's right, but one see
more sir that hogi claim nahi.
But it will create some prejudice. Invoke 11.
I have no claim against him. I have what is the arbitration clause related to the person to whom he has given money. I only introduce him to him. That is the allegation.
Anyway, we'll see.
Your Lordship is disposing it of instruction.
No. 23 only dismiss as withdrawn. Not at this stage.
At this stage.
Premature, not at this stage. You can come. Wait. Yes.
36.
May I please, Lordship? My Lord, petitioner is challenging the cognizance order taken by SDGM Sadar, thereby taking cognizance under section 342, 294, 436, 307, 506, 34 of IPC. And in the meantime, the matter has been amicably settled between both the parties. And
very cognizance order, this one, huh? What are the offences?
Offences, my Lord, 342, 294, 436, 307, 506, 34 of IPC.
Injury report?
Injury report, my Lord, injury sustained by person. Injury report is not there, my Lord.
What is the injury? Nature of injury?
Injury by another, my lord, FIR shows injury sustained by any person, there is no clinching material to connect them to alleged offences. Injury report is not with me.
Then 307 will be quashed without knowing what is the injury.
Amicable settled between both the parties.
Maybe settled, but we have to see if it is a vital part, if you have used some deadly weapon, that has to be taken into consideration, and we have to see what is the credential of this man. Everything has to be seen. It is offense against the state.
Injury report.
You file all these things. This is an incomplete petition.
There is no such
Injury
allegation.
report,
In fact, my friend has not read out the FIR he has annexed. It's an allegation that some people came, two young boy came and they tried to set fire in the house.
Set fire in the?
In the house. They tried to set fire in the house. They were seen by the informant through the window and they fled away.
There is no injury there.
No, absolutely no assault is there. ନିଆଁ ଲଗେଇକି ମାରିଦେବା ପାଇଁ ଚାହୁଁଥିଲେ।
Let us issue notice them.
Yes, yes.
Notice.
Notice.
My lord, in the petition.
He is arguing your case. You have not read it.
ପଢୁନାହାନ୍ତି କିଛି ଆସୁ
You have to read everything and come.
My lord.
Where is the FIR? Have you seen?
Yes.
Have you read it?
No, my lord.
2 o'clock you come, read, satisfy. Otherwise, I'll dismiss.
Yes.
Come at 2 o'clock. Read and come.
My lord.
2 o'clock, huh?
Like,
I'm just passing it over.
one thing, PS case number is wrong.
One thing, two thing, everything I'll hear, but read and come. A to Z and read 482 provision also. Okay? And 307 also, you read and come. Come with all books. Okay, let us see. Let him come.
Yes, yes.
I'm just passing it over. Okay? What is this habit not coming with preparation?
Some defects are there.
Want to cure?
Some defects are there, my lord.
And cure it.
Next.
Allow.
It will be given.
No problem. Anytime you like.
38. 38, may I please, my lord?
Yes.
My lord, there is a defect of nomenclature, my lord. So the direction may be given to the registry to convert it.
What is nomenclature?
My lord, it would be CRLMP instead of CRLMC.
Then it will go some other.
My lord, because of
what is this order challenge?
my lord, 127 order, my lord.
Huh?
Although this can also be challenged in 482, my lord, because 227 is for the power of superintendence and 482 is inherent power, my lord. I have challenged the 127 order, my lord, of CRPC.
120?
127, my lord. 127 3C order. If your lordship may have.
Revision lies against this.
My lord?
Revision lies.
No, my lord. Only, my lord, power of superintendence.
227.
227.
No, 482 is also maintainable.
My lord. So in that case, my lord.
Come on, see, let us see the order.
My lord.
17/2020. Yes, Mr. Maharaj, 482 is maintainable.
482 inherent power.
Inherent power.
Inherent power, that is a supervising jurisdiction.
And
in a criminal
where there is no other provision is available, if you
so 482.
then 482 is available.
My lord.
But there is a provision is that. So
what provision? Constitutional provision under 227 will not bar.
No bar.
You can maintain this.
My
yes.
Lord. If your lordship. My lord, this is the case where the present petitioner, my lord, has filed this application because divorce has been granted, my lord. And
what happened in the impugned order?
Impugned order, my lord, annexure.
Come to the impugned order at page 37.
37.
Starting
from 36.
Present, heard the petition on 127 3C of CRPC for both the sides, wherein the opposite party has sought for cancellation of the order dated so on the ground that dated hearing, the petition. Where is the order dated 5/8/2019? Where is 5/8/2019?
That is annexure 2, page 16.
5/8/2019,
Yes.
16, my lord.
Read it.
My lord, this
Mr.
order
Mahapatra,
emerges-
are you ready? Not
lord,
ready, it seems.
today-
Not ready.
My lord.
It looks like.
Yes, my lord.
So you want some time?
If your lordship will entertain, my lord, lordship may keep it to tomorrow, I'll come to that.
Not tomorrow. Not tomorrow. So
Monday, Monday, my lord.
Monday. 30th, 31st. 31st. Huh?
Order may be passed, my lord, with regard to the defects, my lord, or else
Defects are ignorable. I will entertain this petition. No problem.
that may be
I
observed.
need not note. I do. Why do you worry?
Obliged.
Come prepared.
My lord, today, my lord, because of defects, my lord,
I know you were thinking that you will escape from this court
No,
by
my lord,
saying
that is
cure
not
the
my
defect.
criteria ever, my lord.
Anyway, you now come prepared. Okay.
39.
39, may I please, your lordship? Yes. My lord, I am challenging the FIR and subsequent proceeding, my lord. My lord, in this case, my lord, the petitioner and the opposition two are the employer and employee relationship, my lord. And I was working as a accountant. And in fact, my lord, the allegation is, my lord, it's page 8, my lord.
Have you seen the FIR dated?
Yes, my lord. And the offense is forgery rate.
What is the date?
Date is, my lord, 9/5/43, my lord.
See?
My lord, the
Only FIR is there.
my lord, charge sheet has been filed, my lord. My matter has been compromised.
Charge sheet
A compromise, huh?
Matter has been compromised, my lord.
compromise it.
I have paid all the amount, my lord.
Okay, compromise. Okay. What is the offense?
Offense only forgery rate, my lord. It is compoundable.
Compoundable, na?
My lord.
Go and compound. Why?
No, my lord, your lordship, that process will be lengthy process, my lord. Then your lordship may
the process.
and
therefore
your
you
lordship may
invoke
direct
for it.
take instruction that in the police station there will be the problem will sort out, my lord.
If petitioner has filed this petition for seeking quashing of FIR and consequential proceeding in PS case number so and so under section 308.
302, 320 plus 2 of the
320 plus 2
of the CRPC.
Of IPC, yeah?
No, IPC, my lord, 408 only.
408, that's what I'm saying. 408. 408. So he submits that the offense is compoundable in nature. Since he has settled the dispute with the opposite party number 2,
by the annex 2 series, my lord.
He wants to approach the court below for compounding the offense under section 320.
No, my lord, your lordship may direct.
320 CRPC.
Yeah.
320 CRPC.
Again, my lord, I have to move for the bail and everything procedure will shall follow, my lord. Your lordship may, because if the notice will be,
there is a specific,
I believe, my lord.
If there is a specific statutory remedy available to you, 482 is not available to you. Do you know that? Do you want me to pass a illegal order?
No, my lord. My lord, your lordship may direct.
He would file appropriate application under section 320 CRPC for compounding the offense. He says compoundable. Why are you saying compoundable? I'll have to check then. I go by the statement of a counsel. You don't
My lord,
say that.
with the permission, I am so sorry, my lord. The permission of the court, my lord. It is there, my lord.
Seek permission, you move up.
322 clause, the table.
308, huh?
408. Offense is 408, my lord.
320. 320.
320. Table.
328. कुछ भी बोल देते यार
परमिशन ऑफ द कोर्ट परमिशन कोर्ट है
Available, available.
Honor of the property.
320 kind offense crime. Offense crime. Where is the FIR?
Here, my lord.
Huh?
Because with the permission of the court, my lord.
The allegation is lordship 5,75,000.
No, whatever, but I am looking at the offense.
Yes, lordship. Entire amount has been paid.
Now it is compoundable or not? That is the question.
Compoundable
my lord, with the permission of the court. Go for 325. What is the big
Let me
deal about
take
it?
notice to the opposite party too.
No. So for it, there is a statutory bar. I can't do it. I can't pass it wrong order.
Your Lordship may call it next week.
I have rightly dictated the order.
Your Lordship may call it 1 week after. We will see the.
No. I'm giving a direction to try go to expedite the disposal. What is this? Within 2 minutes you can. What is it?
support support support
There is a problem, Your Lordship.
What is the problem?
The problem is he may not come forward to support now.
That is not compoundable.
Even if court permits, we have paid the amount. The payments are there, all documents we have filed. So Your Lordship may have to decide this. Your Lordship may call it after a week.
Simply urgent. This is the underlining thing.
No.
That's the reason Mr. Sarangi was conspicuously sitting in the back. Urgent, simply urgent. You want that the 482 court should be prove the fact that you have paid the money or not?
I have paid the
It is
Yes.
Why should I prove?
Court need not prove.
Then?
He accept kura bagan na proof dekhe.
Payment bola jai charge sheet hai. Kal charge sheet discuss kariye hum.
You are not carrying. That's not your petition. Is
charge sheet hai not lo.
We should have told the police that I have already paid. You should have given the proof.
He says police has seized those. He says.
My lord, what happened? The police also they kept the mobile phone of the petitioners, my lord. That he has not seized the mobile phone. He said that police said that you come compromise, pay all the amount and come forward to me. Then I will, after the case will be closed, then you will get your mobile phone. The mobile phone is 50,000 rupees, my lord.
All these things are offense is committed, then you have to face the money. Suppose you for some money dispute you are facing 420, 468 and all. In the bail condition, you will pay the money. Then the entire case goes.
And in fact, the affidavit
that is only to buy liberty. But you have to face the trial. Similarly, in this situation, offense is committed. You might have paid subsequently whatever. For that, charge sheet has been filed. Now you have to face it. A lenient view can be only taken for the purpose of bail, because since you have paid, but the offense is committed. Simply urgent for second week or third week. Next.
Last of the Millard, Mr. Hon'Ble को direct to appear in portion of the but not 2 minutes.
Actually,
No. My mother died.
You have settled.
I would have died.
No, you have settled the dispute. Matrimonial, huh? Matrimonial what?
498 and
yes, 498.
husband and wife.
Last day you sought time for. No. Present in person. You want time. Simply urgent.
No, because initially order was passed to appear to the opposite party. Opposite party number 2 will appear.
By order dated 18/12/2023.
Minor.
The coordinate bench has directed the opposite party number 2 to present.
Present and file an affidavit.
And file. Only present. And file an affidavit. Regarding the settlement. Regarding the settlement that is stated to be taken place between her and the petitioner. Legal counsel for the petitioner submits that due to some bereavement in the family of opposite party number two, she could not present today.
Affidavit already filed.
Whereas the affidavit has already been filed. Let the matter be listed on. Kebe? 19th, 18th. 15th will do. No, 15th is 15th. Next week. Because only statement has to be recorded.
15th February. next week.
Next
19th,
week. Huh? 19th, huh? 19th of this month.
Month.
Okay. Yes.
41.
Item 41, I've got a limited grievance that the victim as well as petitioner, both were students in MBJ College Baripada, and both were prosecuting their study that accountancy and management. Allegation is that at the instance of the
Victim and
the petitioner, both were classmates.
where is victim? The victim is not a party.
Yes, lordship. No, my difficulty is FIR question was lost way back in 2022.
You want quashing of this FIR
Yes.
on the ground of settlement.
No settlement. Copy not, sir. Copy maybe, sir. 23/4/2022, more than 1 year, more than 1.5 year lapsed. Except 354C, all are available offense, magistrate tribal offenses. Police is yet to file charge sheet. I'm a student. I'm prosecuting my study. I'm not in a position to even attend my classes because.
What do you want?
My friend is seeking for that copy. I'm permitted to submit copy.
Say, what do you want in this petition? FIR is lodged. Investigation is going on. At this stage,
1.5 year. All the offenses are magistrate tribal. Within 90 days, except 354C, all are.
Whatever. Then what is your relief you are seeking?
Let the.
A tribal by magistrate, therefore I will pass it.
No, that is not the question. Here,
what exactly
statute provides for a particular thing, it should be done in a particular manner and not beyond that. You'll also see, since all the offenses it questioned are magistrate tribal, within 90 days, the IO should take steps for filing up charge sheet. In the meantime, 1.5 year lapsed.
What is the stage of investigation?
No copy has been served.
Then that is right. You see, on 23/4/2022 is the FIR.
Yes.
He is a student.
Yes.
Because of this pendency of this case, he is facing a lot of problem. FIR is registered and jolly well you are sitting. You are not doing anything. Just see the predicament of the student.
Yes.
Right, wrong, whatever. Some
Yes,
FIR
yes,
has come.
yes.
And all are small offenses except 354C.
Yes.
And this boy is a 29-year-old. Which police station?
That Baripada police station.
Chandipur.
Yes.
Give a copy right now.
Yes.
He will
Yes,
seek instruction
Yes.
by 17.
As you know. Regarding progress of investigation. Yes.
Because I can't quash it. Is
Yes, sir.
very
Yes,
The only thing is you tell them that you file the charge sheet immediately. I can't direct
Yes,
to
yes.
file charge sheet also.
Right.
I can't do anything except making you a request that ask the police to expedite, because see the plight of this boy.
Right. I will get instruction. Just now I'm serving a copy to my friend.
Legally, nothing can be given to you except requesting him to
No, that.
tell the police to file a charge sheet, if at all.
Yes.
He is filing closure report.
Yes, that is.
Very good, no problem.
Just now I'm having
Just
copy.
now give the copy.
Yes, yes, yes.
17th,
May I pray,
17th to seek
in the meantime, may I be protected, madam?
Huh?
May I be protected? I'm student. I'm unable to
482,
go out of my
it's
house.
not
madam.
bail code.
No course action, at least
No,
till
that-
my lord
that-
and friend to take instruction. Till then, at least, my
First
lord.
of all, this petition is not maintainable at this stage. And I want to just give you indulgence because you are a student.
Yes.
And you want to, what is the coercive action? Coercive action in a 482 in a quashing petition means I am stalling the investigation also.
No, not stalling. As and when required, I will appear with the investigation, cooperate with the trial.
Then bail.
Provided.
That is what?
Till then, at least I will.
That is what?
Till then.
438?
Till then.
438. That is 438. 438 I can't exercise in 482.
No, till my lord and friend to obtain instruction. Just now serving him a
So
copy.
this is the only thing I can do for you. 438 you might have applied.
No, I have
that
not
might have
applied.
been
Not
rejected.
applied for.
Go and apply. Get it. What is the offer?
I'm serving just now a copy. Let my friend to take instruction.
Yeah. 42. 42.
It is arising out of a complaint case.
More not.
No. So state is not a party.
This is the this is arising out of a
Complaint case.
Complaint
One
case.
CC case. My lord, after the complainant has filed the complaint petition. Since it is a non-cock case, madam, he's filed a complaint petition, madam, and he's.
What happened in 21st September 23? That is annexure 1. What is this?
My lord, that is the order of cognizance.
Okay. What are the offences?
416 and 498. And none of the offences are made out a bare perusal of the complaint petition, also the 162.
No, either 156.3 or 200.
No, my lord, it is a complaint petition.
200.
Yes,
200 complaint. Then 161. Where is 160?
161, no, initial statement.
Only the pre-summoning evidences.
My lord.
Pre-summoning evidence.
My lord, annexure 2.
Yes. Page 25, read. This is the order, na?
So 25 is the cognizance order.
There is the complaint, initial statement of the complainant in the shape of affidavit. And I am satisfied that 416
and 498
IPC.
498.
My lord.
My lord.
Yes.
Your lordship, next page, my lord, the initial statement. May I read, my lord?
This is in fact the pre-summoning evidence.
My lord.
Yes.
My lord, my husband, namely Panchananora, training mate, namely Deepak.
You are reading where?
My lord, page.
The first paragraph. My husband, namely.
My husband, namely Panchanan Khanna, Rona, sorry. Rona's training mate, namely Deepak Kumar Maji, being a long time acquaintance, came to our son's past birthday. That we.
You are Deepak. You are Deepak Maji.
My lord, I am Deepak.
Being a long time acquaintance, came to our
son's past birthday. That we shall. My lord, the complainant is a married woman. We have some relationship developed.
Complainant is a
married woman.
My husband is, he says my husband is married only. Without marriage, how will, where from husband will come? That's the statement.
Came to our son's past birthday that we celebrate at Patapur on 18th November 2018.
At the function, he
tried to impress me a lot. Subsequently, we did not have any contact with him during the COVID-19 pandemic. He often visited us, our Patrapur resident, before COVID-19 pandemic. He bought gifts, clothes for us and remained with us, which I did not find appropriate. But since he was a close friend to my husband, I never expressed my feelings. Subsequently, after the husband's transfer to Fort of Hon'Ble in the year 2022, considering the future and better educational facilities for my son, we decided that I will stay at Pusinda, PS Barango, along with my son, and staying at my brother's place as Pusinda from February 2022. The accused person was posted at Puri. At that time, he started visiting me at our residence in Kusina and confessed his love for me. Subsequently, he attempted suicide once I denied relationship with him, and myself, I am a married woman. However, succumbing to his suicide threat, claims of love, I talked to him. On 15/5/2023, the accused asked me to accompany him to market to purchase a sari for his mother. So I asked my sister-in-law to look after my son and went with the accused. However, the accused, in spite of stopping me, took me to Sai Siddhi Lodge at Puri in the name of some urgent talk. We stayed the night there, and that night he asked me to ask 5 lakhs from my father for purchasing a car. I asked him why he was demanding money if he really loved me, but he did not answer. The next morning, I woke up to find out that he had fled away. I tried to call him on phone, but he had blocked me. He had paid the hotel fee at 6 a.m. in the morning and had left.
Only she asked for 5 lakhs.
5 lakhs. This is the only, my lord. If your lordship go through the provision of section 498. 498 is my lord. Your lordship.
IPC. 498, not A.
No. May I read, my lordship got it? Whoever takes or entices away any woman who is and whom he knows or has reason to believe to be the wife of any other man, from that man or from any person having the care of her on behalf of that man, with intent that she may have illicit intercourse with any person or conceal or detains with that intent, any such woman shall be punished with imprisonment of either destination for a term which may extend to 2 years. My lord,
There is no allegation of intercourse.
my lord. But also no, my lord, with intention, illicit intercourse or conceal or detain. I have not concealed, not
He has
detained.
gone.
Yes, he voluntarily left. She stayed
Yes,
with me.
Mr. Mahajan.
Sir, it is not
Maharaj.
it is a
As a complaint case.
Complaint case.
What is
no
this?
notice to be.
Not, sir.
Notice to
Completely
be.
a fake case. Why? What is the intention behind it?
Intention, my lord, the present petitioner is the friend of the husband of the complainant. They are posting as firemen. And there's some relationship developed. I'm not denying.
It is a one-sided love.
Yes, but there is relationship. That thereafter, my lord was broken. And
But
after that, he has
there is
filed.
no offenses. Sir.
No offenses.
Issue notice.
Yes.
To the opposite party number 2. And peruse the contents of the complaint and the pre-summoning evidence recorded pre-summoning evidence of the opposite party number 2 oblique complainant.
One single.
Opposite party complainant on 13/12/2023 by Learned JMFC Cutter. Full stop. On the basis of which the cognizance has been taken.
No, it is 12 men.
12, 13/12. Cognizance has been taken. Perusal of the contents of the complaint and the pre-summoning evidence indicate that prima facie there is no case made out against the petitioner. Then counsel for the petition submits. No case made out. Issue notice to the opposite party number 2. Opposite party number 2. Opposite party. Opposite party. Full stop. In the next part, in the internagnum, the proceeding before the court of JMFC 2 Kotak in ICC case number 80 of 2023 against the petitioner is stayed till the next date.
Oh, bless.
My lord, may
Yes.
I make a mention? Sorry.
Yes, yes.
I have a matter today, that is item number 44.
Yes.
My friend is also appearing, one of the petitioner, and perhaps Mr. Roger is appearing. After launch, I have some other difficulty. So I pray
Do you have
that.
any problem?
My lord, I have objection, my lord. In this case, this is a case offense under section 302. Further proceeding state. And last date and before on the same request the matter was adjourned. If your lordship is inclined to adjourn the matter, kindly fix a date in the first hour with the convenient of.
After 16th, any day your lordship may fix, I have no objection. 16th, I may not available.
Na 3636 30 30 बाकी लगे माने नेक्स्ट वीक लागला रीच करिवनी फायदा तो I looking into all the stalwarts I know that will take
Point of law, that's why I'm not.
So it will take
Yes,
time.
it's only point of law, nothing else.
The interim order was there.
If there is no point, there is a point of If there is a point, there is no required to a point of
But
yes.
my lord,
30th.
That interim order to.
Interim order to continue.
on that side, if anybody will not pray for adjournment, it will be better.
Believe them. I ask believe them. Believe them that they will not seek time.
My friend is saying that future nothing will happen, will be hell and hearty and.
Item 46, my lord. The only one matter has come, 2 other connected matters are there. May I pray your lordship?
Connected, how it is connected?
My lord, from this very same complaint case,
Okay.
I have filed 2 applications. So one application,
The notice is not issued in this matter.
in this matter, notice has been issued, interim order is there.
Service is complete. Then why can't wait? I'll take, because there are very
Because
less
two
matters.
other matters are there. After launch, your lordship, that are.
I'll come within 5-10 minutes. I'll take up these matters.
So I was requesting all the three matters to come in a particular
Give the numbers of other 2 matters.
Yes.
Note it down. When the matter is called up, even if in his absence, we'll do it.
Yes.
Don't worry.
Bye.
Please give
Yes,
other
just now.
The opposite party enter appearance. Upon Jyoti Paniba.
S. Panda. You are reviewing? He's seeking time? Info? No. Adjourn.
Interim order to continue.
Interim order to continue.
Madam, next. I want to.
I will give it. You give it. Yes.
Your Lordship, I want to give it of a mention memo.
Not now. Mention is 10:30. Mentions all mentioning at the 10:30.
Item 3.
Password?
Password.
Okay.
Nobody
is there. Adjourn February. Last week, February, March. Next.
Item 5.
Item 5, unfortunately, I have not brought my file. So next to I have also gone through the file, but
2 weeks.
Yeah.
2 weeks. After 2 weeks.
Supposed to fix a date so that matter.
No, date will be fixed. Yes.
Item 8.
Proceed to look at this order. We have approached Hon'Ble High Court, and the Hon'Ble High Court has stayed that matter order of.
That matter has not served the copy of main.
But just see what had happened is there is a stay order operating, the stay order, specific stay order passed by this court, and still the trial court is proceeding.
No, thing is that what I have gone through that in the meantime, that that WPC number where stay order have been obtained, their vigilance is not a party, neither the locator. They have obtained the order, and
but there is an order. It was intimated to you.
No. That has been intimated during course of cognizance, after cognizance.
In the impugned order,
that is mentioned. That is mentioned. They have been. Your Lordship kindly see.
Merely because it is order 39-1 injunction or what?
No.
It operates in rem. It is a High Court order.
My Lord.
How can you disrespect High Court order?
No, that is up to your Lordship. I am not on the.
Not up to. Why have you proceed? Which is this court?
Your Lordship kindly see. The impugned order.
Just see the order of the coordinate bench. Order of the coordinate bench. 136. Come to 136.
Your Lordship kindly see.
Come to 136, sir. Where is that order?
The impugned order, Your Lordship.
No. The coordinate bench order where this.
134, Your Lordship. 134.
134.
34.
Prior to that, may place Your Lordship. Kindly Lordship on to
134. 1 minute.
Page 64.
Yes. 135. Come to.
I have gone through that. Your Lordship kindly.
Specifically say
order
interim as an interim measure.
My Lord.
And it is directed that there shall be no effect to the order dated 13-1-2023 involved herein as Annexure 4.
Mal.
On the basis of 13-1-2003, the entire the proceeding has been initiated.
My Lord.
Which is operation is stage.
My Lord. Your Lordship kindly, subject to your Lordship's kind consideration. Page 64.
64. Okay.
The order of the Lokayukta.
Yes.
The order of the Lokayukta was, well, also in page 64.
Yes.
There the last
That is
question.
13/1/2023 order.
My lord. We therefore accept the investigating report in totality, accords permission and direct the Director of Vigilance Odisha to file the charge sheet against them of offences so and so. So the direction was to submit charge sheet. The clerk direction to submit charge sheet.
And it was said.
No,
by the High Court.
then I'm coming to your lordship. Subject to your lordship can consider. I am not on that. Your lordship then come to when the order was then charge sheet was submitted when. It is admitted the charge sheet was submitted on 31/1/2023.
On 40 to 20.
ଟିକେ ମୁଁ କହିଦଉଛି 31/1/2023 ରେ
To be correct. That's what I'm placing.
ତ ଆପଣ ଯାହା ଦେଇଛନ୍ତି ଯାହା
ମୁଁ
ଅଛି ମୁଁ ସେଇଟା
ଆପଣଙ୍କୁ order paste କରୁଛି.
Okay, charge sheet was filed.
charge sheet was filed. The direction was to submit charge sheet. According compliance to that direction, the IO submitted charge sheet. There is no illegalities has committed by upon the point of the IO. Then when this the order they have obtained in writ petition, it was very much within the knowledge of the petitioner that the vigilance is submitted charge sheet. By that time, in February, 9 February, that is so by that time he could have brought it to the notice of, he has suppressed that fact that charge sheet in the meantime. That order has been
That order is, according to you, that order.
the order has given effect to. That order has by that time the order interim order was passed. The order has been given effect to.
That's right, but wrong or right, whatever.
My lord.
There is an order.
That I am not done.
The order of the High Court. If you are agreed, you should have challenged that order.
No, ଆମେ ତ ଜାଣିନୁ ଏପର୍ଯ୍ୟନ୍ତ. They have not.
The trial court records it.
High Court record ଏବେ ସେ ଯୋଉଟା ଜଣେଇଲା ପରେ
ତାପରେ କାହିଁ challenge କଲେନି? ଯଦି if you are so aggrieved about it.
ନା trial court ନାଇଁ ଆମେ ତ ସେତେ your lordship kindly visualize the situation. They have obtained an order. The order was that next date of listing it will be 9/2/2023. The order was there. The next date of listing. Then 9/2/2023. After 9/2/2023, the case was we are in February. After in the meantime, 1 year near about 1 year is elapsed. The case has not yet been listed. I am not in that.
What you are trying to say is they have concealed the fact from the court and obtained this order. That's what
order, and the order, the very order was
conceal
given.
the fact and obtain order. Wrong, right? I am not going into the right or wrong of that matter.
My lord.
There is a order of the High Court.
My lord.
That you don't proceed. You don't proceed.
No. Order.
Or and that matter is still pending. Have you moved an application for implement there? You have not taken any step.
Order was very specific. The order dated 13/1/2023 shall not be given. Order 13/1/2023 was to submit charge sheet. By the time of
charge sheet was already submitted.
By that time, order was given effect to. That order was given effect to. That is my sole point of submission. And in any case, they have not served me a copy of them. I have to take instruction. 6 masare charge pay ପାଇଁ କୁହାଯାଇଥିଲା.
Meanwhile, you hold your hands. Tell the trial court to hold it.
नहीं सेटा तो ये तो ऑर्डर तो अच्छी दैट आई किंतु सेटा मते देखिया पड़ा योर लॉर्डशिप नो सो फार माय प्रेडिकेमेंट इज कंसर्न लेट इट कम नेक्स्ट वीक सो दैट आई कैन ऑब्टेन इंस्ट्रक्शन 6 मासरे थिरा चार्ज पेमेंट ପାଇଁ 6 मासर ऑर्डर टा एबे चैलेंज करछन सी जनवरी ऑर्डर टा इन द मीन टाइम 7 months have elapsed तनु सेटा आसु नेक्स्ट वीक रे आसु सो दैट
come on 17
one clarification for first thing we have not obtained the order. This honorable court on its own wisdom has passed the interim order. Second thing, Your Lordship, kindly see the impugned order at page 156, Your Lordship. The date of the charge.
Okay, what? You have got the copy? When?
Today.
Today he got the copy. Let him
already served the copy. I will not dispute that other thing. But Your Lordship, them next week they are fixed for filming of charge.
When?
My seniors take
when is the
advantage.
date? When is the date?
The date is on
6/7/2023 କହିଥିଲେ 6/7/2023 now we are in 2024 कौन ହେଇଥିବ ମୁଁ ବି ଜାଣିନି.
They have fixed the date. Next week they have fixed the date. That is the date is Your Lordship.
See, this impugn order is up when was your
12/6/2023.
After that charge has not been framed, but on the next week on 16th they have fixed the date for the filming of charges, Your Lordship. For that purpose we have immediately moved before Your Lordship.
I can undo everything if they do it.
That can be.
You give instruction not to proceed.
In the worst case, let them file an adjournment application on taking this plea that already that
you instruct the prosecutor not to proceed with the matter because I have taken very seriously. If there is a stay order, you have to respect it.
No, with all respect we have to. We have.
Then Right, wrong, whatever. You move application, that petition is still pending before the coordinate bench. You have not moved an application for variation. You should have moved an application saying that, see, they have concealed this fact and obtained the order. You have not done anything. And you don't obey that order also. What is this?
No, no, ସେଥିରେ କ'ଣ ହେଇଛି ଲୋକାୟୁକ୍ତ ଅର୍ଡର ଚ୍ୟାଲେଞ୍ଜ ହେଇଛି ନା that I got
ସବୁ ଜାଗା ଆପଣ ସେଇଠି ଯାଇ କହିବେ ନା ଏଇଠି କହିଲେ କ'ଣ ହବ?
ସେଟା ତ ପାର୍ଟି କରିନାହାନ୍ତି ଆଗ then any case that will be seen I have to take instruction on that.
ପାର୍ଟି ନ କରିଥିଲେ ଆପଣ ହେଇପାରିବେନି ପାର୍ଟି।
ନା ହେଇପାରିବ ଏବେ ଦେଇଛନ୍ତି ଆସୁ ସେଟା next week ଆସୁ।
ପାର୍ଟି କରୁଛି
issue notice to opposite party number 1 so on so gives notice
so far as may Samir one thing vigilance is not a party that
opposite party number 2 then
may I suggest one thing my lord?
Yeah, where is the memo party? Just see, you have not just see.
I will correct it, Your Lordship. I immediately have the mistake has been committed.
And you want an interim order, you file the petition like this. Why should the court will interfere?
I beg apology. That's the mistake. That's a serious mistake I have committed, Your
Lordship. See the memo parties. Nobody is there.
That's serious mistake I have committed, Your Lordship. I have to agree that. I beg apology.
What is the state of Orissa? Who is representing state of Orissa? Is the governor or chief minister?
I beg apology.
Who? And this is the level of drafting you have. Business department is there. Business department is not party. I am simply urging. Next week you seek instruct.
Yes.
On 17th.
I beg apology.
No apology. See, High Court level, at least you are the youngster. At least High Court level, some kind of standard of pleading should be there.
Actually, having some sympathy, I will immediately correct it.
So that is by 17th you seek instruction. To whom I will issue notice, you tell me. If there is no one party,
I will immediately correct it, Your Lordship.
You tell me to whom I will issue notice.
Business department.
There is no respondent.
I beg apology, Your Lordship.
There is no opposite party.
I have committed a mistake, Your Lordship. I have committed.
And you want urgent? No, the mistake has to be penalized by simply adjourning. 17th.
But you see, I have the clarification.
17th. You must learn lesson out of it. 17th. There is no respondent.
Should be kindly ignore my. It's the first time.
Why should you ignore? I would have ignored if somebody else would have been there. You are a very serious lawyer and one of the finest lawyer I have seen. Till this mistake.
I beg up.
What the youngsters will learn
done by the chamber is committed a mistake, Your Lordship.
Very bad.
I'll condone this time, Your Lordship. I'll make sure, Your Lordship, this will never happen again.
Now immediately go and type a memo of parties and come.
My Lordship.
Go and get it right now.
My Lordship.
Go. Get it. Wait for some time.
May I suggest one thing, my lord? Let him file the memo.
First, let us see who is the respondent. There is no respondent, sir. I'll issue notice to whom?
I will do it. I will do it ASAP as possible.
Go and get it done now.
Yes, much obliged.
So let him.
Can permit him to correct it here.
I can do, ma'am. There is no problem, but I don't excuse youngsters.
I have to learn a lesson, Your Lordship.
He should go and get it done, and then
I have to learn a lesson, Your Lordship. I will do
go
it.
And do it.
I will do it immediately.
Your senior might not have seen it. These are small things. Nobody sees it. And you brief like this.
It's our colleague's mistake, Your Lordship. I beg apology for that. I will do it immediately, Your Lordship.
You get it done immediately. And the junior who has assisted you, tell him to type. Okay.
Obliged.
24.
May I please, Your Lordship?
Yes.
My lord.
Yes.
There's an application under section 482 CRPC, my lord, seeking for quashment of the proceeding, my lord, instituted against several persons, out of whom, my lord, out of all the accused persons, eight persons.
You are Sanjay Behra.
I am Sanjay Behra and Praveen Bez.
No. Sanjay Behra is the only petitioner here. You have also done the same thing, it seems.
No.
There is no petitioner now.
Yes. Only Sanjay Behra. Yes, ma'am. It is only Sanjay Behra. I am sorry, my lord.
Yes.
My lord,
and what is again you have done? State of Orissa. What happens, I tell you, the real difficulty, I'll tell you. If this, suppose I pass the order, you go and file SLP in Supreme Court, because I was from that court, I'll tell you. And the advocate record has to run around the registry to get it numbered, because there is no one represented. Suppose you will write represented through so-and-so, they will match the memo of parties of the High Court. There is no one, and there will be a defect, and you run around. It will not be registered. It will be listed before single judge.
Your Lordship is
Chamber judge.
correct, but here our practice.
And the clients will be after your life.
Throughout our, my lord, the days, my lord, our practice is this, my lord.
That is very.
In criminal cases, it is not required to be represented. Otherwise, the
represented through the superintendent of that area where FIR is there, or IIC of that police station where FIR is there. Somebody.
Secretary Home Department.
Or Secretary Home Department.
Home. But that sort of practice is not here.
Our practice is
Otherwise,
practice is flowing from the procedure. Procedure is a party has to be represented. You are having a wrong practice means you justify the wrong practice.
In writ applications,
Supreme Court rules that
properly get it represented.
The fundamental principle of the pleading is there should be party properly represented. So somebody has to represent.
Your Lordship is correct there, madam. But our practice is this, madam. We have been doing.
In appeal also, only state of Orissa.
That's not.
That is to be my lord.
There should be some representation. Otherwise, see, the problem I tell you now, practical problem. What we are
Your
feeling.
lordship is correct, but we are following that practice since long from the time. It is state of Orissa.
rules required to be changed.
Because, my lord, the state council is there, my lord. They can take care of the things, my lord, here by.
You throw in there.
I'm not.
But ideally, there should be some representation.
Yes.
Otherwise, this difficulty comes.
It will mention as a home. Just vigilance lekha hoji.
हाँ.
Something home lekha.
Home lekhi dewe.
Home lekhi dele.
Either at least.
State of Orissa bracket or home.
Yes. That should be the idea.
Seti filing wala problem.
High Court rule that
You have that rule position.
Set a
Rule
rule.
might be silent.
Yes.
So you are taking advantage of the silence.
Your lordship may pass that order so that.
No, why should I going on? But that's
Sabu bail application में हम इनकी state of Orissa करके दूँ. Bail application all the criminal matters.
See, ideally, state is prosecuting you, so therefore state is a party. That's different. But state has to be represented by someone.
And the OPID and other matters they mention.
OPID, why?
OPID.
State of Orissa.
State of Orissa bracket.
OPID. Then vigilance.
Special counsel is there, so it has to be.
If you implead someone, represented through, that will also not be a defect. It is more convenient.
Defect
more convenient.
This way also, the registry never. That is the practice from the beginning. We have been doing this, my lord. So, my lord,
Home Secretary.
Commissioner come secretary. Home and disaster management.
नहीं home नहीं सेटा disaster management आउची
Home Secretary, Principal Secretary,
home
department. Police is under Home Department. Home Department. Police. Okay, let us see.
But here I have read for quashing of the proceeding, my lord, against the present petitioner on the ground that all the accused persons, my lord, 8 accused persons, those who are involved in the commission of crime as per the prosecution case, my lord, they have been acquitted from the charges after a prolonged trial. They have been acquitted. I have
you might have absconded.
No, I was shown as an absconder, my lord. And there were also 2 others who were shown absconder. Your lordship may kindly have a glance at Annexure 3, my lord. The other 2 persons, they had applied before this Hon'Ble Court under Section 482, and the proceeding has been quashed on the ground that it will be an abusive process of court if the proceeding is allowed to run against them, my lord.
There are 3 accused persons those were absconding. 2 approached this court.
This court.
Yes.
What happened, my lord? 8 accused faced the trial, my lord. They have been acquitted because charges in different count, my lord. 2 persons involved 302.
No, he's only
in the page, my lord, here case, my lord.
Page 38, come to page.
My lord.
Ambika Base and Praveen Base.
Praveen Base.
My lord.
These 2 people were also absconding.
My lord.
And they approached this court and
proceeding
now the court has quashed the
Can you see page 41? But same order, my lord. Page 41.
41.
Towards last 3 line. Fourth. It is further noticed in the evidence of PW 13 that his brother earlier was taken by accused Nursingha, Likun and Litton by Swapneshwar Mahadev temple at about 10 p.m. on that day. Sanjay, the defendant petitioner, Nursingha, Litton and 2 others came to the house. When her mother opened the door, they overpowered her and gagged her mouth. The 2 unknown persons took her to their clutch. Sanjay, Nursingha and Litton took her mother to the adjacent room. Then 2 unknown persons took her to that room. Then all the accused persons forcibly made her mother lying down and administered some liquid to her. Then her mother died. The specific allegation is Sanjay, my lord.
What about Nursingha and Litton?
Nursingha and Litton, they are acquitted, my lord. And he was absconder, my lord.
Absconded, these 2 people are absconded.
And that my lord, this petitioner, my lord, this petitioner also filed another criminal miscase 2804/2018.
Dismiss for default he jaytala
setare se kare tha
seta dismiss for default he jaytala
so
restore heta kare tha same order ha can challenge here, my lord. Puni seita gote hitala seita
restore he paribo nolle separate
the moment that has been non absent dismiss means, my lord, that order has been confirmed already. The moment non absent dismiss hela na
dismissal
so same order seta restoration kare katha
2022 live law Supreme Court 612 there it has been held that there is no bar for filing a press application if it is not decided on merits.
There is no res judicata.
Yes, it will not operate as res judicata. So
same order challenge here.
Instead of filing an application, because if I file an application, that will be again
What is the offense? What is the offense?
302.
Offense is 302 with other offenses, my lord. My lord, initially the FIR was lodged under section 492 with other offences, my lord.
But the witnesses
subsequently charge sheet has been filed, my lord, under section 302 with other offences, deleting 498. A different story was created. That is why PW 13, what my lord friend is reading, my lord, that is the version of PW 13. Your lordship may kindly then come to page 42.
Yes.
The learned court below has disbelieved the version of PW 13, my lord, because she has given a completely new story, my lord, to the prosecution case. What it was.
PW 13 is the only witness.
The only witness who claims to be an eyewitness, my lord. And she gives a completely different story than the prosecution which has been launched initially on the basis of the FIR, my lord. That is why your lordship may kindly
is the daughter of the deceased. PW 13 is the daughter
of the deceased, my lord. Your lordship may kindly come to, my lord, the that page 42, paragraph 14, my lord, page 42, your lordship, sees, my lord. Paragraph 14.
Paragraph
14, which has been quoted by this honorable court while dealing with.
That's what I'm reading. Para 9.
No,
page
para
41.
14. Para 14.
Para 14 of
page 42. Running page 42, my lord. 41, he read the 41, your lordship will find. Paragraph 10 is, it is further noticed in the evidence of PW 13. So these are the.
He read that.
Yes. And page, next page, your lordship may kindly see.
Yes.
Page
PW
14
13
is
has
quoted.
introduced.
Page 14 is. PW 13 has introduced a new story which is contrary to the contents of the FIR. She has alleged that the accused persons undressed her and that is that
and
is
there only 201 charges are there.
The in search. Gotala acquittal order and coupled with this fact that the other 2 have been given indulgence by the honorable court in 482.
That's the reason I try to balance it. I'll just see what else could be done.
Your lordship may kindly.
Okay, thank you very much.
What is it?
Yes. You got it?
Yes.
I
also make a conditional apology.
take it. Take it on record. Take it on record and issue notice to opposite party number 2 now. Opposite party number 2.
And 3.
3.
SP is also a party vigilance, SP vigilance.
Opposite parties returnable within 1 week. 1 week. Learned counsel for the petitioner submits that the matter is settled for matter is listed for hearing on the question of framing charge on the next date of hearing. In the next week. You don't know the date, huh? Next week. 17, next week. It matter 17, next week. And therefore, he submits that he would be moving appropriate application for adjournment. Adjournment. Same shall be considered by the court, keeping in view that the present matter is the issue is seized before this court.
May I pray another thing, man? There are another CRLMC 1483 2023 is pending. Same petitioner.
You have filed it?
Yes.
What is that?
After the anticipatory bail.
Rejected.
When the no, it was allowed, your lordship. Despite of allowing the anticipatory bail, the same sessions judge, he has put him under jail. For that, he has filed a CRLMC. In the CRLMC was released on bail and subsequent services has also been allowed. But it was.
I have to take it. Let it come along with that. Let it come along with that.
Least the CRLMC number
1483 of 2023 and WPC.
Place the
record
of CRLMC so and so.
Certificate and a WPC along with that WPC. And he may be directed to supply a copy of the WPC and so that will be better.
I have called for the record.
My lordship.
Okay.
The lordship is urgent to 24.
17, na?
No, sir.
17, I will make absolute the stay, if that is the case. If there is already there is a stay, if you have no explanation, you have to go by that stay.
May I pray one thing? You're seeking urgent.
Okay, then
24th, let it come 24th.
No, then 30th.
31st. Much obligation.
They make the interview absolute. Why?
I have given entry mode. Don't worry.
May I please
Yes.
My lord, petitioners are challenging the order of cognizance.
36, pass over, huh?
My lord, petitioners challenges the order of cognizance dated 29/3/2018, passed by Lawrence SDGM or Katak, thereby taking cognizance under section 342, 294, 436, 307, 506, and 34 of IPC. And FIR does not reflect any injuries sustained by the informant. Only brief fact is that the petitioners were threatened and abused abused her in obscene languages and burnt outside of her house the electric bulbs and wires, and no injuries.
There is no injury,
my lord.
What do you want?
Issue notice to and informant and the accused person are the neighbor and
have they settled?
And amicable settle between them.
Okay. Issue the petitioner has filed this petition seeking quashing of order dated. Which order? Prayer, just see prayer, page 6. What is this prayer? Read very loudly this prayer.
The petition therefore prays before your lordship to be gracious enough to consider the above stated fact and circumstances and admit this CRLMC, and after hearing the parties, quash the order of cognizance passed by Lawrence Court of SDGM.
Order of cognizance dated
29.
Where have you written? Where is the date of cognizance? What is this prayer? Why are you so casual? There is nothing. I told him to read. You have not read the prayer? Prayer is defective. Anyway, what is the cognizance date now?
29/3/2018.
What have you written? Order dated 29/3/2018, passed by learned SDJM bracket S Cutter in connection with so and so. 2017. On the ground that the parties have under section so and so, on the ground that the parties have settled their dispute. Next, issue notice to the opposite. Just see memo. Opposite party. Memo just memo parties. First page.
Secretary,
Next page.
Next page.
You have written there in handwriting. What have you written?
Madhusmita Bera, aged about 36 years. Son of Bhanta Bera.
Son of? What have you written?
Husband of Bharat Behera.
I tell you, this is this kind of attitude. This kind of petitions are not even entertainable in the lowest possible court in the earth. You have filed a 482 petition. No prayer, memo of party is not proper, provision are not written, no annexure, quashing. What is this Sunny Bharat? What age? I don't know. Age about 37 years. Bharat Behra.
Husband's name?
Sunny Mandap. Mandipura. What is PS?
Madhusmita Behera.
Sunny Mandira, PS Mangala.
Mandira.
Near Sunny Temple.
Sunny Temple could live.
Yes, Sunny Temple. সেটা কিছু লেখি না দি বাট এটি রিটার্ন এফআইআর এ রিটার্ন আছে সনি টেম্পল মাতা মঠ
You have to go by
পিলা তো
চলো opposite party number 2 returnable after first week we bring them, we will pass.
I beg to apologize, my lord. One PS year of the affair wrongly written in the petition copy.
You tell me what is rightly written. What is rightly written in the petition? You tell me. सब हाथरे खाली फ्लूड मांगी ओवरराइटिंग करके जाता लिख के चलो anyway I'm issuing notice, bring the parties, we will quash it, okay? And hence next time when you file the petition, be careful about it, because this is High Court, okay? Give a date, first week, 8th February. Bring the parties, I'll record the statement and quash it.
Find this joint affidavit.
Oh, you file, okay. The petitioner submits that he would file the joint affidavit regarding the factum of bringing on record the factum of settlement. He may do so by next date of hearing. And meanwhile, I'll give you stay also, no problem. Meanwhile, the proceeding before the court, prayer, Jesse, prayer, and the
SDC further cut off.
Further proceeding in connection with it is 2017 or what?
17.
17.
My lord.
100% sure. 283 up 2017. Corresponding to ST case.
ST case, my lord, 2018, 37 of 2020.
37 of 2020.
And PS case number is my lord 283 or
Just pick it up from the recording. He doesn't know anything. Karke stay karo. 8th. Come on 8th.
Item 43.
Perhaps this is the first case in Odisha High Court after since 48. Perhaps this is the first order. Yes, this is the first order.
So liberal to him.
And your lordship, we are highly obliged before lordship to appreciate this application.
This young guy.
Yes.
And he also learned something from your lordship.
And he learned.
That's the reason I told him to go and read.
Yes.
He might have somehow, somebody might have approached. Why to discourage that?
My lord, this is also for quashing on the ground of compromise between the parties.
Offense?
Offense 307 is there, and two affidavit, one by the informant and one by the.
Show me the injury report.
Injury report, my lord.
Both are present here. That's right, but injury, where?
Injury report, my lord.
Injury grievous.
Grievous injury in
No,
spite
grievous
of.
Belly.
Which part of body?
Belly.
My lord, what has
Weapon?
One knife.
Knife. My lord, what has happened? Actually, some injury was there, but he was having earlier some problem in the belly. There was a need of operation. So soon thereafter, they have operated it. But in the meantime, they have settled the dispute between themselves.
When she was in need of operation in the belly, so he
Immediately, he has done that.
What is their relationship?
They are relatives, one village and neighbors, and having some relations. My allegation is that on that day, the husband of the informant was performing a feast along with his friend. The petitioner went there, asked them money, and when they refused, he threw all the utensils, and thereafter, when they protested, thereafter all that happened. Must be the grip of alcohol, I think so. That has not been reflected. But
he was tested, where he was alcohol found.
But that it seems. Otherwise, my lord, for
It's a family feast. In a family feast, all these things happen.
Yes. My lord, I am having a
At the spur
judgment.
of a moment, he might have reacted that way, and
Yes.
yes, Mr. Raghuda, what?
Judgment, sir.
No, that medical
injury, but.
And a judgment is there of the Honorable Supreme Court.
Judgment.
07.
Okay.
And parties are present also.
Parties are present.
And what purpose shall be sought? If
That's right. That is the test.
Yes.
That is the test. In fact, which judgment you are trying?
My lord, that is, I am having a copy.
I have passed so many judgments.
No, one judgment.
You show me one judgment, I can quote it.
Yes.
Eight.
That your lordship may kindly.
Because in these kind of matter, there is no threat of further appeal. So therefore, it has to consign to the court.
Para 4, your lordship may kindly.
This is Supreme Court, huh?
Yes. Para 4.
Justice Ranjana Mishra. Para 4.
Next page. Next page is relevant.
326, 307.
Yes. Offenses which involve moral turpitude, grave offenses like rape, murder, etc., cannot be effaced by quashing the proceeding because that will have harmful effects.
Okay, write down. There is only one petitioner? There is one accused?
Yes.
Only one accused?
Yes.
The petitioner is facing a trial for allegedly committed offense under section 301 section. What are the sections?
Under section 341, 324, 325, 307, 294, 506. First paragraph.
506.
Yes.
IPC in ST case number so and so. Okay.
In
GR
case.
Sorry, GR case number
649.
649 of 2022, arising out of Connors PS case number 228 of 2022, pending in the court of JMFC Connors. JMC Connors. The ground of quashing is that the petitioner has entered into a settlement. Enter into settlement with the opposite party number 2, who is the informant and victim in this case.
Not victim, informant. Victim is her husband.
You have to implead victim. That's necessary.
No, they are present.
But you have not impleaded. Because at in the case of 307,
yes,
you can't quash a FIR once you enter into settlement with the informant, the victim has
My
to.
lord, victim is today present. Affidavit oath commission पाके भी दे दीजिए.
Victim ही दीची.
आज्ञा. दिया है जी flag.
Victim ही रवि.
आज्ञा. आज्ञा.
Info कौन लगी? Informant. Who is the informant? The victim is.
Has also.
What is the name? Victim.
Pushpanjali Rautray.
Huh?
Yeah, injured.
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 The husband is. You have filed the affidavit now.
Khogeshwar Rautray.
Khogeshwar Rautray. Victim oblique injured is Khogeshwar Rautray, who is the husband of the informant, opposite party number 2. They have placed on record a joint affidavit.
No, 2 different affidavits.
They placed on record affidavits, separate affidavits.
Yes.
Reiterating their stand regarding the settlement. I have perused the documents placed on record, and the allegation against the petitioners is that during a family feast, there is a quarrel, and the in the fit of rage, he has attacked the victim by.
While the husband of the informant injured and others arranged the feast.
Huh?
The husband of the informant injured and his friends arranged the feast, not the.
After the.
No. A feast
is going on.
Being organized by the husband of the informant
That
and
means injured.
other friends. Informant nije hoche injured.
That's what I'm saying.
Not family.
There was a family.
No, not family.
That is family only there.
No.
How does it make difference? Family and friends.
Yes.
Family and friends. There fit of rage. The petitioner attacked the
husband of the informant.
Attacked the victim. Khogeshwar. What is his name? Khogeshwar Rautray. The husband of the opposite party number 2 and injured him in the belly. Therefore, the police charge sheeted the petitioner for various offences, including the grave offence of 307 IPC. The parties are residing in the same locality, and to buy peace and to maintain tranquility in the area, the intervention of the gentry in the locality, they have entered into a settlement. The parties are present. The petitioner, the informant, and the husband of the informant, being the injured, are present in the court. They are being identified by their respective counsels. They have also placed on record their Aadhaar card, photocopy of their Aadhaar card to establish their identities. Next, by taking into consideration the identity. MS led counsel Srimati Jena and has relied upon a judgment reported in so and highlighted para 4 of the said judgment to submit that although the case is under 307 IPC, apart from other offences, this court under the inherent jurisdiction 482 can give indulgence and quash the criminal prosecution as the parties have entered into a settlement. Mr. Ragada appears for the state submits that indeed there is no legal impediment to interfere, legal impediment to quash the FIR in view of the judgment cited by MS Jena Supra. Judgment Supra cited by so-and-so for Supra. Para 4 of the judgment reads as under. Para 4 utar. Next. Judgment Supra reproduce hereunder. Taking into consideration the aforementioned facts and circumstances and the facts and circumstances and the contents of the affidavit, separate affidavit filed by the parties to the proceeding. I am of the view that if the petitioner is subject to the rigors of the trial, it would be a futile exercise. It would be a futile exercise. Therefore, it is a fit case to interfere at this stage and quash the entire proceeding. Quash the entire proceeding. Accordingly, the FIR charge sheet, FIR, what is it? Charge sheet FIR.
By the time, one line may be added, my lord. In the meantime, charge sheet has already submitted 27/9/2023. Investigation completed.
The FIR on number so and so, and consequential proceeding thereof.
GR, yes.
Thereof are set aside.
Yes.
Set aside.
One line may be added, my lord. In my submission, the charge sheet has already been submitted.
Mr.
Investigation completed.
Mr. Raghunath's submission, just write down. Mr. Raghunath also submits that meanwhile the charge sheet has already
Submitted on 27/9/2023.
submitted under submitted.
Charge sheet submitted.
Submitted under submitted. Only submitted. Offense the same offense.
Same offense.
We change it, na offense.
नहीं
302 ही येतील और का कथा ऑपरेशन कोडतला तो 302
Technical charge stage. 307 charge sheet.
46. This is 40.
43. Now
44.
Arjun, my lord. Mr. Senior Advocate, Mr. Mahapatra.
Yes. 45, huh?
46.
46. Okay. 46. Yes. Adjourn. पूरा ये मेंशन कब लगी हाँ सकाळ मेंशन कब ले हाँ मेंशन कब ले उसी दिन रिकॉर्ड कर मगे प्लीज सेम पार्टी है ना पार्टी अलग ना देखो सेम पार्टी Counsel for the petitioner 46 na? Counsel for the petitioner states that there are other connected matters pending before this court being criminal CRMG number so and so and request this court he would have came 2013 or 23 na came other that 23 na and the same may also be heard analogously list this matter along with these two matters.
47.
May I please, your lordship?
Yes.
This is a matter, your lordship, on the last date of hearing, that's a belated filing of the TDS. We had filed it, belated file of TDS, your lordship.
Yes. I remember. Oh, a minor offense.
Right, your lordship. 47. So there are judgments in between also, a number of judgments came in which a lenient view has been taken because only that interest part, your lordship asked the opposite counsel, your lordship, to how much the interest part so that I can pay it.
My friend.
Yes.
Item 47 the copy didn't have
47 is a Union of India, not the copy. It's the Union of India, your lordship.
Union of India.
Mr. Mahapatra was appearing on the
Babita Sahu ki appear
she is not appearing, but Mr. Mahapatra is appearing.
SS Mahapatra.
SS Mahapatra.
Yes.
Union of India.
They have to come.
But they have not come. So I don't know why. No, see, no.
My problem is that
48 also I have mentioned.
How could I? Good to 50. 50 are 46 thousand.
48 remains.
Oh, chalo, 48. Let us wait. Who knows? They may come. Otherwise, I will take it up. 46 that? 46?
46.
Arjun.
After
950 Arjun.
Yeah, आपनों को है. Hey, 1 minute. Yeah, that's the whole morning. I will not entertain. If they have adjourned and
The other party will not
have
present,
minimum courtesy to inform the other side. But
Yes, exactly.
see, that is the whole difficulty. If the court is lenient, the bar is not cooperative. That's the whole difficulty. Then obviously, then we will be like that only. What? Naturally, this if you have asked for adjournment, minimum courtesy you have to inform
the opposite side.
Against the adjournment you will not.
How Arjun hapani? Henceforth, both party will be happy.
No adjournment. When
Both the side will be there, then
no, call record.
yes.
What
is this? Date might have been fixed. 23rd. Apna bhi 23rd. This is unfair. You must convey the other side that this is unfair. Yes. What to do then?
My lord, only difficulty is that the charge is for next to you. My lord may stay the charge because otherwise my petition will be infructuous. I have deposited the, your lordship may stay the further proceedings so that and your lordship may fix any date.
On 16th, put it in the first 5 matter.
Mine matter.
16.
First
5 matters.
Yes, yours.
First.
Because last time somebody appeared.
Yes,
this
your
time
lord.
I can't do ex parte and that to stay. That doesn't.
My lord 16, your lordship.
It will be called first. It will be in the regularly, but mentioned to be there.
No, it will
No,
it will
within
listed in top of the list.
top of the list, then it will definitely reach. But no, otherwise they will not list it in the top of the list.
He'll do it.
My
List of it.
Item 49, may I pay this month? Last week, my lord.
This month it is very heavily,
Otherwise, first week or second week of February.
That's what we have given.
24.
First week and second week, again, there is a holiday and all. So therefore,
Second week, your lord.
again the same problem. I'll change the date. He has taken the date. You will not inform. And he'll come and say, this is what.
He deserves this. Because in copy with attitude, he deserves this.
But deserves it in the same time, the court is in soup. Again, matter will be urgent.
Mix about. I don't know why he didn't come today.
Let it be, just see, otherwise you bring him and mention so that we can call him and mention him. Tomorrow, we will
He
change.
left the court, I think.
But tomorrow he'll definitely come. Tomorrow, Monday. Yes.
48.
May I please, Lordship?
Yes.
Lordship, noting is there that record has not been received, Lordship.
Sorry?
Record has not been received, Lordship.
You were telling me in the
Yes,
morning,
yes,
huh?
Lordship. As per the order dated 21/9/2000.
21/9, huh?
Yes, Lordship.
21. You are enjoying interim order. Now, where is the record, calling of record? We submitted that a document relatable to these which are ended up in PAN report. Where is the order of calling for record? There is no order.
Yes, Lordship. Order.
If you are referring to 21/9/2023 order, court below is directed to submit a report in
Yes,
this
sir.
regard.
Sorry, pardon, Lordship. That is report, Lordship.
There is no report.
No. Yes, report.
Just take it up. Report is there.
No, Lordship. In noting is that no report not received.
Just see, take it up.
Someone is exhibit document.
No report. You have to specify who is that court below. by the order dated 21/9/2023, the coordinate bench of this court had directed the court below to submit a report in this case. However, the report hasn't come on record. By reiterating the aforementioned direction, the court of court of JMFC Jaleshwar.
Yes.
The court JMC Jaleshwar, now JMFC Bogarai, Gram Nyalay. Bogarai is directed to submit the report by next date of hearing.
One submission. Stay order is there. Despite of this stay order, lower court has proceeded the case.
That might be the reason that the order might not have been communicated.
Here, Lordship, order has been communicated. That's why I have filed another petition. Lordship, kindly tag it to that petition.
That petition is what?
CRLMC.
What is the prayer?
That is the prayer, Lordship. Therefore, it is prayed that CRLMC may be admitted, and after hearing the parties, the same may be allowed by quashing the order under Annexure 5.6.
The order which is passed after this
Yes,
order.
yes.
So you should have moved application. Why separate one?
Lordship, because another cause of action arises, that's all. Lordship.
So, counsel for the petitioner submits that despite the interim order of stay dated 21/9/2023, the trial court has proceeded and passed certain orders. Against the said orders, she has preferred a separate petition, being CRLMC number
4607 of 2023.
4607 of
23.
2023. The said matter also to be listed along with the present petition. List both the petition. Number लिख लियो, देखिए कोई दियो, भाई क्या लगियो, and next interim order to continue. Interim order dated 21/9/2023 is to continue. Okay. Anything? Yeah.
Date.